What officer list number 1 na 2 na ತಗೊಳ್ಳೋದು first? What officer? List number 1 ಅಥವಾ 2 na ತಗೊಳ್ಳೋದು first?
1 sir.
Thank you, madam.
ಮೇಡಮ್ ವಿಕೆಟಿಂಗ್ ಒಂದು ಐ ಹಾಕಿದ್ದೀರಿ, ಮೆಮೊ ತಗೊಂತಾರ ಕೊಡಲ್ಲ.
ಎಕ್ಸ್ಟ್ರೀಮ್ ಅರ್ಜೆನ್ಸಿ ಕೊಡಿ, ಕೊಟ್ಟರೆ ಅಲ್ಲಿ ರಿಜೆಕ್ಟ್.
ಅದೇ ಅದಕ್ಕೋಸ್ಕರ ಅವರು ಒಂದು ಐ ಸ್ಟೇ ತಗೊಂಡು ಪೆಂಡಿಂಗ್ ಇಟ್ಕೊಂಡಿದ್ದಾರೆ, ವಿಕೆಟಿಂಗ್ ಹಾಕಿದ್ದೀರಿ.
ಅದೊಂದು ಮೆಮೊ ಕೇಳ್ಕೊಂಡ್ ಬಂದ್ಬಿಡು ರವಿ. ಅದೇ ಅವತ್ತು 2:30 ಒಂದು ಮೆಮೊ ಕೊಟ್ಟಿದ್ದು PS ನ ಕೇಳ್ಕೊಂಡು ಏನಾಯ್ತು?
Proceedings ಎಲ್ಲ ಕೊಡೋದಾ? ಕೊಟ್ಟಿಲ್ಲ.
It's already 12 o'clock tomorrow.
No, we are waiting for them.
Tomorrow, mentionings tomorrow. Yes.
For being spoken to, list number 1, scale number 1.
Lord,
Sridhar Prabhu.
this matter, my lord, I am the culprit who moved the matter. There's a memo, my lord. There is an interim order, my lord, which we had produced. My mistake, my lord, I should have pointed out to your lordship's page 7, my lord.
Yes. Page?
Page 7. Page 8 is the relevant page, my lord. The interim order that I had paid, 22/4/2026, my lord, this honorable court passed this order. Based on that, my lord, we had prayed the interim order, but some other interim order, my lord, has been passed. I should have pointed out. Next page, your lordships were to see page 9. Page 8 order is, my lord, my prayer. Page 9 order has come. This says, my lord, that 15% shall be governed by so and so.
No, petition you are referring to?
Yes, the petition, my lord, the petition that is before your lordships 1.1 is, my lord,
1.1. Yes.
yes, that is, my lord, page 9. That is, my lord, 21589 of 26.
Let me look at it.
Please. Serial number 1. Yes, that's all. Serial number 1, my lord. Lordships may see the interim order dated 28/7/26. This is the interim order passed.
28/7.
Yes, my lord. This has reference to 12725.
No, there is no 28/7 in this file.
No, there is, my lord, serial number 1, my lord. The Altilium, my lord.
1.1.
Please, Altilium Consulting is, my lord, the case. Yeah,
No,
serial number 1, my lord.
GM Sugar and Energy.
No,
is
no, my lord. 1, my lord. Altilium is
Do the first
21589. I'm sorry, because
Do the first one. This is second one.
What are you referring to, sir?
Altilium.
No, but
Interim
what
order.
is that?
Interim order. You are not on record.
On the
Altilium
memo?
Consultancy.
Yes, my lord. 21589. I'm persuading your lordships to see the order dated 28/7/26.
28/7.
Please, my lord. Lordship's order.
Hmm.
Considering the order dated 22/4,
Hmm.
your lordship said, my lord, the pending consideration of so and so, the petitioner shall continue to pay the earlier so and so. Your lordships will see the 22/4 order on page 8. This only says, my lord, precipitative action be not taken. That is what, my lord, I am praying that order may be kindly, my lord, replicated.
22.
Yes, page 8, 22/4 order. My lord, in that petition that your lordships have referred, I am referring to the last paragraph, last but one paragraph. Having regard to the submissions made upon so and so, court is of the opinion petitioner has made out a case for so and so. Accordingly, so and so are directed not to take any coercive steps. That's all I have prayed, my lord. This 15%, etc., is in the other matter.
There is some confusion. This
Please.
page 8 you are referring is your petition. of
No,
this.
page 8 of the memo, my lord, that I have.
That's
Just,
what
I'm so sorry. I'm so sorry, my lord. I should have. I didn't see that your lordships are not there. My sincere apologies.
Yes.
Page 9 of the memo is your lordship's order, my lord,
Yes.
of 28/7/26.
Yes.
Lordship said that, my lord, considering the order dated so and so, consideration of the writ petition so and so, shall not be any.
According to you, the order date is wrong.
No. Order date, the interim order to be passed should be on the lines of 22/4/2026, which only says precipitative action be not taken. But this 15%, etc., is not part of that 22/4 order. I am requesting your lordships to kindly pass an order in terms of 22/4/6 order. That's all.
My lords, we appear for the respondents. We haven't been served a copy of the memo.
No, they are not on
unless we
record
see-
in one. This no service, my lord. They are not on record. 22/4. Your lord,
Already have
same
passed-
order has to come.
Already have passed an order relying on some order. According to him, that is not the order which we
Yes,
find it
yes,
in the
yes.
order.
But we
passed.
don't have any of those papers that
They
your
are not-
lordships are referencing for
As
us
far as this,
to follow what is being said, my lords.
No, at this point of time, I am only modifying the earlier order.
Please.
So at that point of time, you were not represented. So it doesn't matter.
Obliged.
So you will serve the papers on you. This court on 28/7/2026 passed the following order. Learned counsel for the petitioner submits that Basing on the order dated 22/4/2026, this court has passed an order. It is submitted that, however, in the said order, the order pertaining to the other petitions is reflected concerning the same. Para number 2 of the order shall be substituted as follows.
Last but one paragraph.
In the light of the order dated 22/4/2026, the respondent number 2 and 3 are directed not to take any coercive steps pursuant to the DSM 2024 regulation until the next state of hearing. However, it is made clear that the petitioner shall continue to comply with and make payments, if any, in accordance with the regulation framed by the Karnataka Electricity Regulatory Commission. And respondents are at liberty to seek for modification of the vacation of the, that you don't require. So, commission KERC, that's it.
Yes, we are deeply obliged.
No,
Lord.
that,
The regular date is, Lord,
My lords, I undertake to enter appearance on behalf of the respondent number 1. My lords, my instructions are with respect to the challenge to the 2024 regulations. The CRC is moving a transfer petition before the Supreme Court. So therefore, the other matters may be detailed and heard by this honorable court while pending. Insofar as 2024 is concerned, we can await what the Supreme Court says.
No, which one?
My lords, 1.1 before your lordships, GM Sugars is with respect to challenge to the 2022 regulations. That requires consideration by this honorable court. The 2024 regulations, my lords, a transfer petition is being moved before the Supreme Court.
Oh, there are several matters.
There are several matters.
So this 1.1 has to be heard independently.
Please,
The
my
remaining ones has to be.
but let that happen.
The remaining ones, my lords, are transfer petition is being moved, my lords.
Yes.
So
That,
1.1.
Lord, I
My
don't.
lords, I mean 1.3, my lords, just one submission. My lords, the being spoken to us in 1.1, your lordships have clarified.
Yes.
The rest of the matters, my lords, there are interim orders of this honorable court. Parties are to complete pleadings. My request would be, my lords, let that be put over, my lords, for the parties to complete pleadings. If and when a transfer petition is served, my lords, we will of course intimate to this honorable court. Till date, for example, we are not served with any transfer petition notice. In fact, there are interim orders in the other matters also, my lords, which your lordships have extended.
I supplement my learned senior friends.
1.1 can be taken separately, my lords. It deals with the 2022 regulations. It has nothing to do with
Trying to say
2020.
is 1.1 has nothing to do with the other ones.
No,
Please,
no.
the pleadings are also complete. Pleadings are complete in 1.1.
No, this order, what is passed is pertaining to the other cases.
No,
The other cases, the
my lords,
being
I'll just
spoken to,
clarify
my
that in a
lords.
minute, my lords. My lords, in 22/4 and 27/4, there were two orders of this honorable court, my lords. We had challenged in the 27/4 order the 2024 regulations. The order was that the previous regime will continue to apply under the present
That is one
regime.
set of
One set of.
repetition.
Those matters, my friend now says that the CRC wants a transfer. We are not aware of that as yet. My friend's clarification was, my lords, limited to 1.1.
Yes.
Rather than today, my lords, indicating any bifurcation, they have come in as a set. I would request that your lordships, my lords, have it posted over for parties to complete pleadings.
Please.
In the meanwhile, if there is a transfer petition, my lords, they can bring it to the notice of this honorable
May
court.
clarify,
And
My-
Lord, if the transfer petition is moved and those matters are moved to Supreme Court, remaining matters will be before the court and we will make submissions in that. Why, my Lord, preempt that transfer petition? Nobody is stopping them from moving a transfer petition
My lord,
in
that said,
anticipation of their.
correct.
May-
That
my-
said, I have no objections for bifurcation of all the matters, my lords. They could come
I
independently.
have also
my
no
lords.
objection, but then, my Lord, there is a regular date. Pleadings have to be complete. As we stand today,
What he says is correct. When unconnected,
they are connected. My Lord, DSM regulations are the challenge.
Your interim order itself is different from the others.
Yes.
So it is not connected.
To
So
that extent,
with that clarification, this 1.1 will be delinked from the other matters.
Please.
All other matters come with delink 1.1. In other matters, look at it if there is any till the next date interim order extended. List these matters after a month. Give a date.
Your lordships have given 7th September, my lords, in
Let it be
1.3.
Yes.
It could be, my lords.
Let
all
it
matters-
come on that day. This
Please.
matter also, 1.1 also, let it come on that day. Yes.
My lords, the interim orders to continue in the other
That I
matters.
said.
I'm so very
Grateful.
grateful.
What is your name? You said you appear for whom?
My lords, for CRC, my lords.
In all the matters.
Yes, ma'am. Please,
In all the matters, regulatory commission, so and so, central regulatory commission, so and so appears.
My friends being spoken to dragged us all to
no,
court,
no,
my
I'm
lords.
sorry, my Lord, I'm guilty because I should have pointed out. My apologies.
Grateful.
Oh, you thought that it is coming up for hearing.
Yes, my lords.
Yeah, the fortune of my.
Just leave it there. We'll see when it comes.
List number, serial number 2. What is it? For orders matter, serial number 2.
Yes,
For the petitioner, my lord.
Ravishankar S.
memo for withdrawal. Where is the memo? The memo is for seeking to withdraw the writ petition to avail the appropriate remedy. Same memo is taken on record, dismissed as withdrawn.
Serial
The
number
liberty
3.
to file appropriate petition. The time is 2 months, 2 weeks. Registry shall return all the documents by keeping the xerox of the way. Yes,
Serial number 3.
For petitioner, my lord, I filed a memo for withdrawal, my lord.
the writ petition is filed. To withdraw the petition, submits that the prayer that is sought in the writ petition is already worked out. Accordingly dismissed as withdrawn.
Serial number 4. Shruti.
Appear for the petitioner. Your lordship.
What is this memo for disposal?
My lord, in fact, what has transpired in this matter is the sale certificate is already issued. Now he has to agitate up before the trial court if he is aggrieved by the issuance of the sale regarding the sale of the property as per the attachment and subsequent sale proclamation and other procedure followed by the executing court. Instead of that, now the matter he has preferred a writ petition because alternative remedy is available for him to agitate up before the executing court or any fresh suit he has to initiate.
Your lordship, suit is for specific performance.
No, what is the,
No, I understand your lordship.
what is the impugned order I'm asking?
No, I challenged the proclamation order, your lordship. And when I was filed the writ petition on that day, only the court issued the proclamation for the sale. In the pendency of this petition, my learned friend, before granting the interim order, the sale took place and I was deposited the money. What he is saying. This honorable court granted the stay for the proclamation and directed me to deposit a 5 lakhs rupees. I was deposited that 5 lakhs rupees as per the in compliance of the interim order passed by this honorable court. Prior to they granted the interim order by this honorable court, the trial court on the basis of the proclamation order issued the sale certificate in favor of the respondent. So now my contention before there also, I question the specific decree in the RA court. That RA is pending. So based on that, we sought for that. We are ready to comply with that order in portion. So we sought for the questioning because in the pendency of the appeal, they filed the execution and in the execution court issued the proclamation. In spite of I brought to the notice of that, my appeal is pending. That is all. Now the trial court issued the sale deed in their favor. And as per this honorable court, I was deposited the 5 lakhs.
Take back that money. Take back that money. As per the interim order, whatever you
But my
paid.
RA appeal is pending, challenging the
No, we
original.
can't
decree.
interfere. When a sale certificate is issued on a writ petition which is filed seeking for questioning the proclamation, we can't interfere. So I'll leave all the remedies available to you. And the amount you are deposited also you can withdraw.
My only request is before this honorable court is that your lordship permit me to withdraw my 5 lakhs and agitate my remedy in the RA. So
No, all rights are left open to the parties to be adjudicated in accordance with law.
and say the sale deed is the subject matter to that appeal because the very decree
Yes,
is.
please come. The present writ petition is filed. Questioning the order dated 12/1/2026 passed by the senior civil judge and JMFC, Chandrai Patna, in execution number 75 of 2023. By virtue of the order, the sale proclamation was issued by the court. It is that order sheet. Order sheet. And when the matter came up for hearing, a coordinate bench of this court on 10/4/2026 has passed an order dated 9/2/2026. No, the coordinate bench of this court has passed an order dated 10/4/2026, whereby the proceedings impugned proceedings or stay on the condition that the petitioner shall deposit 5 lakhs before the executing court by the end of April 2026. It is a submission of the land council for the petitioner that the said amount is already, as per the interim order, pursuant to the interim order, they have deposited the amount. Land council, next paragraph, land council appearing for the respondent submits that pursuant to the proclamation, the sale was conducted, sales certificate is issued, and now it's for the petitioner to question question if he is aggrieved, he has to question those orders, and nothing survives for consideration in this writ petition. Next part. Land council appearing for the petitioner submits that he has filed a appeal is pending consideration. He has come before the court questioning the proclamation. Even before that, the court has passed a sale certificate. Hence, the petitioner's interest shall be protected. Next paragraph. Having the counsels on either side, there is a material on record. The petitioner has questioned the proclamation issued by the trial court. Thereafter, the court has passed an order, and the sale certificate is also issued in favor of the respondent herein. In those circumstances, nothing survives for consideration in this petition, and the petitioner is at liberty to avail all the remedies available to him in accordance with law. However, the petitioner has deposited an amount of ₹5 lakhs pursuant to the interim order passed by this court. Hence, this court is of the view that the said amount has to be returned to the petitioner. Accordingly, this court is passing the following order. The writ petition is disposed of, giving liberty to the petitioner to avail the appropriate remedies in accordance with law. Number 2, the registry is directed to return an amount of ₹5 lakhs.
No, it's deposited before the execution.
An amount of ₹5 lakhs deposited pursuant to an interim order passed by this court shall be returned to the petitioner.
Cell number 5. Now we'll see.
That was expected to take up the lordship. After hearing the matter, my lord directed my learned friend to get the
What do you say on
imposing of 20,000
allowing this
rupees.
petition with 20,000 costs?
Please, Your Honor. But my lord, not to file further application.
No,
because-
I made it.
I will say,
Please.
by the next date of hearing, we'll fix a date.
Yeah,
On
that's
the
what-
day he should complete.
Yes,
Yes. Where is the order?
my lord, page 80, my lord. Page 80, my lord.
The petitioner is before this court. Agreed with the order dated, what is the date of the order?
22/6/2026, your lordship.
22/6/2026, whereby the court
Rejected.
had dismissed an application, that's I number 22 and 23, filed under section 151 CPC, seeking to reopen the case, and also another application under order 18/17, read with section 151 CPC, seeking for permission to lead further examination in chief. The petitioner before this court is the plaintiff in the suit. He has filed
For partition.
the suit seeking partition, that is suit is of the year 2016. The trial court has dismissed this application, observing that on 22/9/2025, plaintiff has filed I number 17 and 18. Said applications were allowed on cost of ₹1,000 and DW1 was recalled. On 15/10/2025, DW1 finally cross-examined. Advocate for defendant submitted that no further defendant's evidence. Then the matter is posted for arguments. Thereafter, plaintiff has filed I number 19-21 on 5/11/2025. Same are allowed by passing the order on 7/2/2026 and DW1 is recalled. Again, DW1 cross-examined on 3/6/2026. Then posted for arguments. After one adjournment, again plaintiff has filed present application. By considering all these aspects, the court is of the view that there are no grounds to grant permission to lead further evidence and accordingly dismiss the application. Next part, land counsel appearing for the petitioner submits that there is no intention on the part of the petitioner to drag on the proceedings. He has specifically stated in the affidavit filed in support of it that what is the reason why he wants to reopen the case and to examine the witness. It is submitted that unless this application, unless and until this application is allowed, it would cause a lot of hardship to the plaintiff. It is further submitted that he will not, they will not, if a day is fixed, on that day, they will cross-examine who? What is the application?
Dependents.
They will cross-examine the defendants. Defendant number?
All the defendants.
All the
They will
defendants.
cross-examine the defendants and they will cooperate with the trial, with the proceedings before the trial court. Land counsel for the respondent submits that the trial court has rightly considered all the aspects and rightly dismissed the application. When the petitioner has filed repeated application, earlier applications were allowed on cause, but again he has come up with the present IA number 22 and 23. And the court was right in dismissing the application and no interference is called for. Next, having heard so and so. This court has perused the order. The court had rightly considered the aspects and rightly has observed that the petitioner has taken several, in spite of passing earlier, in spite of earlier applications being allowed, he is coming up for one application or the other. This court has heard the learned counsel of the petitioner and also perused the affidavit that is filed in support of the same. This court cautioning the petitioner that he shall not delay the proceedings in this manner and balancing the interest of both the parties. This court is passing the following order. The writ petition is allowed and allowed by setting aside the order dated so and so. Consequently, I number 22 and 23 are allowed. The petitioner shall cross-examine the petitioner plaintiff shall cross-examine the witnesses on
18.8 is the case.
Lead
schedule.
for further chief.
Further chief of.
Further chief of PW1.
further chief and cross-examination.
I will cross-examine. If he lead the further chief,
Yes.
then defendant side will cross-examine the PW1.
Should also be
The
given.
IA number 22 and 23
Yes.
are allowed.
Yes.
And the parties shall complete the chief and cross
On the same day. Your Honor.
on the same day. Which day? When is it coming up?
On 18.8, now that I was
Matter
told.
is now 18.8.
Matter is now
On
listed to
18.8.
18.8 only, my lord.
On
So
18,
that,
it shall be complete.
they will have
completed.
time to see what is.
No, before that, I number so and so is set aside on the condition that the petitioner shall pay an amount of rupees 20,000 to the respondents.
Please, sir.
And shall not file further application.
That I cannot.
That I will
say.
not.
We can't because we can't anticipate and say.
Highly obliged, your lord.
Acha.
The hearing, serial number 6, Sagar G. Nahar.
I appear for the petitioner in this matter, my lord.
Matter
The suit
belongs
is
where?
that of specific performance, my lord, in which the defendant number 16, petitioner before this court, is a bona fide purchaser, pendant light during pendency,
When was
suit
this?
for specific performance,
When was it?
2012,
2012. When did you purchase the property?
2022. I was not aware, I was not made party. There was an interim order subsisting, I have to be honest to this court. 22, I purchased it. Thereafter, the land comes to be acquired by the KIADB, my lord, and they award compensation in my favor, which is also dispersed to me. I am also impleaded, SLAO is also impleaded. What is under challenge is the order of the trial court at Annexure A, my lord. The order starts at page number 26. The reasons are at page number 30. The trial court has directed me to deposit the entire compensation money that I have received of 7 crore 50 lakhs, my lord. May I please go through the reasonings, my lord? Page number 30, para number
Now
6
what will
onwards.
happen? You are a pendant light purchaser.
Please, my lord.
What other order you expect from the court?
If I may, my lord, there are certain judgments saying that a person who files a mere suit for specific performance is not entitled to claim anything in the compensation amount, my lord. If anything, he is only entitled to relief of refund of his earnest money at the hands of the vendor. Here is a case where,
Why do you anticipate that the specific performance suit will be dismissed?
no, even if it is, it cannot be, my lord, because it's frustrated because land is already acquired.
So you should have the benefit of it.
May I please go through the relevant judgments, please, my lord? The first judgment, copy, could you?
So a person who is not diligent is, now it is inuring to his benefit.
May I please take my lord through these two paragraphs, please, my lord? Para 11 at 712, my lord.
Is there any judgment of the Supreme Court?
Please, my lord, Karnataka as well as Supreme Court, I'll take my lord through all of them.
Pass on
In
the-
fact, there is one judgment of my lordship itself, my lord, on this point. May I please, para 11, on the basis of the dictum in the aforesaid decision. They refer to a dictate judgment of the Supreme Court, my lord. Para 11, I am reading, please.
Yes.
On the basis of the dictum in the aforesaid decision, learned counsel for the respondent persuaded me to take the view what the Supreme Court has taken the view that when the subject matter of the suit for specific performance is acquired under Land Acquisition Act during the pendency of the proceedings, the agreement holder is entitled to the compensation that is awarded under the Land Acquisition Act. I am afraid that that is not the dictum laid down in the aforesaid decision. The Supreme Court proceeds on the basis that when the land is acquired during pendency of suit for specific performance, the agreement becomes incapable of performance. But their lordships have considered the position of law under the English law and under the Indian law as to what is the relief that can be granted to the plaintiff in such circumstances. Their lordships held, in spite of the land having been acquired, the plaintiff is entitled to compensation as provided for under Section 21 of the Specific Relief Act, for the contract became unenforceable, not due to any fault of the plaintiff. As stated earlier, their lordship further held that unlike the English law, under Indian law, even in such circumstances, Section 21 of Specific Relief Act enables awarding compensation in lieu of and substitution of specific performance. The mere fact that their lordship took into account compensation due under the land acquisition compensation as the measure for damages for fixing the compensation does not mean the plaintiff in such a suit is entitled to all the benefits which accrued under the land acquisition proceedings. The agreement holder cannot be substituted in the place of an owner. The agreement holder, when his contract becomes unenforceable, is only entitled to compensation as provided under Section 21 of the Specific Relief Act, which the court is entitled to determine taking into account the facts and circumstances of the case. No doubt, in considering the measure of damages, the compensation awarded under the Land Acquisition Act for the land may be a relevant factor. The aforesaid decision has laid down the law that the plaintiff in such a suit is to be substituted in place of the landowner in regard to compensation under land. In that view of the matter, the aforesaid decision cannot help the respondent plaintiff in contending that he is entitled to all the benefits arising under the land acquisition proceedings. Thereafter, my lord, a coordinate bench of this Honorable High Court specifically raised the question with regard to whether they are entitled to anything, my lord. That is at para number 13, at page number 16, please, my lord. The questions is specifically framed. Para 13, page 16, my lord. Having heard the learned counsel for the parties, the questions that arise for consideration are
Para 20.
Para 13, my lord, at page number 16. 1-3. Left hand side, my lord, para number 13. Having heard the learned counsel for the parties, the questions that arise for consideration are whether the petitioner, being an agreement holder, can challenge the acquisition proceedings or claim compensation, whether the parties may seek a reference for adjudication under Section 30 of the Land Acquisition Act and seeks deposit of the compensation amount before the competent court. The answer, my lord, is at para number 33, my lord, at page number 38. The apex court in the case of the apex court in the case of
Para number
33, please, my lord, on the left hand side, bottom last, page 38, bottom last. The apex court in the case of GH Grant held that a person interested includes anyone who claims to be entitled to compensation, whether as an owner, mortgagee, lessee, or other person having interest in the land or its compensation. The right to receive compensation may devolve by operation of law. Agreement holder whose contract of sale has not culminated in a registered conveyance, whose title or possession has not been judicially recognized, cannot automatically be treated as a person interested in the acquired property. The mere existence of an unperformed or disputed agreement does not confer a proprietary or compensatory right in the land or its value. Recognition under Section 30 arises only when the claim demonstrates an existing legal or equitable entitlement capable of judicial determination. Unless the agreement is proven to be valid, substituted, and supported by consideration, the holder cannot maintain a claim for compensation as his right has not yet established in law.
No, this is one scenario.
Please, two more points may I please bring forth to this court. Now, if my lord takes my petition, the plaintiff before the trial court first approached this high court, my lord, wide writ petition at page number 47, please, my lord. They approached the honorable high court, my lord, in the month of April itself, the prayer of their writ petition, if my lord observes, is at page number 68, my lord.
Yes.
If my lord observes, this is dated 24th March 2025, my lord. They first approached this High Court on 24th March 2025, seeking prayers in the nature of page number 68, my lord.
Oh,
My lord,
oh, that.
page 88, directing. Thereafter, when they did not get any interim relief before this court, the court till date has not granted them any relief. Thereafter, they go approach the trial court and file the IA. The IA I have produced at page number 70. The date of the IA may kindly be noted, my lord. It is filed in the month of July, please, my lord. If my lord observes, it's 11th July 2025. They approached this honorable court on 24th March 2025 first.
When were you impleaded?
I was impleaded in 2024, much prior to both of these IAs. But they come to this High Court, to the Honorable High Court. Honorable High Court does not grant them any relief. Thereafter, they go to the trial court, file an application seeking essentially the same relief, which essentially amounts to forum shopping, my lord, which I may also, one judgment I am relying on to buttress that order. And lastly, I will rely on one judgment of my lordship itself, which says that the trial court cannot order for anything in relation to the compensation because Land Acquisition Act is a code in itself. Here, my lord, referring to various judgments at para number 24. Delhi High Court. Delhi High Court. Para 24, please, my lord.
Yes.
The counsel for the appellant defendants in his written arguments in this context had made apposite reference to Supreme Court judgment. A classic example of forum shopping is when a litigant approaches one court for relief but does not get the desired relief and then approaches another court for the same relief.
For this, no judgment is required. Yes. For this purpose, no judgment is
And
required.
this is on the point. That is why I brought it, my lord. Last judgment that I am referring to is my lord's judgment, definitive judgment saying that the Land Acquisition Act is a code in itself and the trial court, civil court, is exempted from exercising jurisdiction with regard to disbursal of compensation.
Yes.
Para 3 records the facts. The trial court has discussed the case of the plaintiff and observed, may I please?
Yes.
Para 3, my lord. The trial court has discussed the case of the plaintiff and observed that the notification which is issued by defendant number 11 statutory body is not in dispute. Without challenging any of the acquisition proceedings, the present suit is filed for bare injunction and the court has relied on the judgment of the Honorable Apex Court in the case of dash in Land Acquisition Act. By necessary implication, the power of the civil court to take cognizance of the case under sections 9 of CPC stands excluded and the civil court has no jurisdiction to go into the question of validity or legality or proceedings under section 6 and subsequent proceedings except by the High Court in a proceeding under Article 2. It is thus clear that the civil court is devoid of jurisdiction to give declaration or even bare injunction being granted on the invalidity or right contemplated under the Act. It is observed that the only right available for the aggrieved person is to approach the High Court under Article 226 or the Honorable Apex Court under Article 136 with self-imposed restrictions on their exercise of extraordinary power. Relying on the said judgment, the court has held that the suit is not maintainable. Para 5, my lord, are the findings of this honorable court, my lord. The relief that is sought in the suit is granting an injunction restraining the land acquisition officer from taking steps to disperse compensation amount in respect of the scheduled property on the basis of the final gazette notification. The Land Acquisition Act is a complete code in itself, which contains all the provisions right from issuance of 4-1 notification till the disbursement of the amount. The intervention of the courts when the land acquisition proceedings are initiated, which are in the larger interest of the public, is very limited. There are several steps under the Land Acquisition Act whereby the parties who are the owners of the property will get an opportunity to present their case before the LAO. In case there is genuine dispute with regard to the title of the property, the same has to be brought to the notice of the LAO, and on such reference would be made to the civil court, even if they are not happy with compensation respect. In between or any of the procedural regularities, if a person is aggrieved, only remedy available to them is to come before this court under Article 226 of the Constitution and the civil court.
Yes.
May I please put forth last 2 points, my lord? What could not have been directly has been done indirectly, my lord. This honorable court has consistently held that land acquisition amount an agreement holder is not entitled to, my lord. Here is a case where I have paid full consideration to the owners, and I have lost the land because of the acquisition. Now asking me to even deposit the amount puts me in peril. More importantly, this comes into perspective is proportionality, my lord. If my lord observes, they had agreed to purchase the property in 2007 for a sum of 58 lakhs without verifying the title. It's forthcoming in the plaint itself. They have paid advance of only 15 lakhs, 15 lakhs. From 2012 till today, the suit is pending. Till today, evidence is not led. In fact, the plaintiff in his plaint itself, I will just show you that relevant portion, my lord, has mentioned that the defendants have denied the execution of the agreement. They have denied the receipt of the money, my lord. May I please take my lord through that?
Not necessary for this application. Yes.
Please, my lord.
Yes.
There are such circumstances when the rights have not yet crystallized. Please, my lord.
Yes, counts for the respondent.
Please. Notes, there are three propositions which would emanate while the court is hearing this. Notes, first of all, whether notes a purchaser pendent lite notes can claim better rights over the property notes than that what is already preserved by the court. Number one. Notes, the question number two, notes which would have to be possibly formulated, notes is a person who purchases a property in violation of an order of injunction which is subsisting, notes, is he entitled to any pendentality equities? Pendentality equities. And notes, sub question notes is whether he can even be heard till notes his contempt is purged. But I'm not going to press the second part of the question, but I'll just point out whether he is entitled to any equities notes in view of his purchase which is in violation of an interim order. Lastly, notes, what I would call as a substituted res in the current case. Notes, when the property in question notes takes a different shape, that is in form of a compensation, is not the court entitled to preserve the same under section 94 of the CPC, and notes, inherent powers can be used or not. This is the only.
But unfortunately, Supreme Court says otherwise.
Notes, I've just pointed out. The Supreme Court has said, notes, per se an agreement holder cannot be a part of the reference under section 30. An unproved agreement. This is, I think, the judgment what he has referred itself, notes, possibly her ladyship Justice Hemaleka's.
Not this, not
Yes.
the land acquisition, not the judgment of mine he's relying on. I'm saying about the Karnataka judgment.
That is with
earlier
respect to an
judgment.
amendment. I've read that. That is the court there was dealing with an amendment application.
No, Justice
That is
Hemaleka's
why
judgment is
Justice
relying on.
Hemaleka's judgment. Notes, if your lordships could just go on to para 18. There, notes, in one of the judgments, notes, the Supreme Court has held so. That is why, notes, I think parts which are convenient. That is, if I could just take the lordships to para 16, there, notes, in the same judgment.
Read.
Reference is made to section 21 specific relief act which empowers the court to award compensation in substitute of specific performance where the contract cannot be carried out. Reliance is also placed on Jagdish Singh versus Nathu Singh, wherein it was held that where a contract without a fault of the plaintiff becomes impossible of performance, the court may grant compensation in lieu of specific performance. It is therefore urged that an agreement holder is not remediless and may recover from the acquiring authority the value of the property determined in the acquisition proceedings, as said the value represents the property itself. Now, in the current case on hand, notes, there are two facts which are important for the moment. Notes, from the fact sheet, it is borne out. Notes that the current petitioner Bernards was impleaded as a party defendant on 13/3/2024. This date would assume a bit of irrelevance. Notes, then on 29/10/2024, his written statement is also taken as not filed before the trial court. He is not contesting the matter there. Notes, he believes that he has come notes, only for the purpose of taking compensation. I'll just point out how it is.
Before that, I just want
Yes.
to ask you one question. Forget about this purchase. Forget
Yes.
about his purchase. No, during the pendency of the suit, the property is acquired by
Yes.
the authorities. Compensation is paid to him. In those circumstances, will you ask the court, will you seek for a direction that that amount shall be deposited?
To the court under section 64 of the new land acquisition act. Notes.
No. Anyway, you can't ask the land acquisition officer because you're just an agreement holder.
I can
Land
only
acquisition
tender
officer-
an objection.
No, to before the civil court in a specific performance suit, can you ask the court that the amount whatever he has received pertaining to this property be deposited?
That is not, that is the equity.
But that appears from the judgment, Supreme Court judgment.
That is not
on
so.
that.
That is not so. That is why I wanted my lordships to have a closer look at the same judgment. But before your lordships could just there, two facts and then my lords, the propositions which deal on the point of what is the position of such a purchaser. May I just take my lordships to, can I just hand over?
Where is this GH grant? Where is the judgment? Where it is extracted? In the judgment you relied on of Justice Hemleka.
Please, my lord, I may make it.
This is.
My lord, that is
DH grant,
extracted.
I'll just explain what is DH grant there.
No, we'll
In
read
DH grant,
No,
what
we'll
the Supreme
read
Court
it.
goes on. Your lordships are right. Para 33, what the Supreme Court has referred to there, kindly see. Lord, sir. This is
Not para 33, inside, in the discussion,
where page 38, are your lordships referring there?
No, my lord, I will just assist my lordship.
38.
No, where it has been first discussed is what.
that is at page 26, I find some discussion on this grants case.
Please, my lord. My lord, 25 deals with Rajama's case, my lord,
It's a different.
and it's essentially para 16 onwards, my lord, that all the judgments are discussed.
Turn over to page 33 minutes, para 26. Para 26.
No, at internal page 15 of the order, discussed about 1, 2, 3, 6,
Your lordships
8
come out to
judgments.
internal page 33 then, para 26.
That is where the discussion I have seen, that before that is it any, we'll see the judgment. Now, the whole basis for the court to pass this order is the judgment of the apex court in grants case. So,
And
My lord, in fact,
grants
multiple
case-
cases are discussed, not
no,
just.
no, but
Yes,
ultimately you look at.
my lord actually caught the pulse of the case, my lord.
Apex court in the case of GH
Yes.
grant held that a person interested includes anyone. So let's see, I want a judgment on
Please.
this point because I have my own doubts on this.
Please, my lord had held the pulse of the case. If I was not at all there, if the landowners had not sold the property,
At
and
that-
if during
no,
the
no, no.
pendency,
So on that point, what is the judgment of the Supreme
my
Court?
lord, that is, I may just pull out, my lord, in the first judgment that I had referred to, 1996 Karnataka, that judgment pulls out, even that relies on GH grant, my lord.
So why are we looking at the other judgments? Let's see the grant judgment itself.
Please, my lord.
I'll pass over, please get the judgment.
At what time, my lord? 2:30, please. I'll make sure I get all.
2:30 minutes.
2:30.
Can your lordships have this tomorrow if it is not?
My lord, today is the date for compliance before the trial court.
Yes,
From
2:30.
It's 2:30, there are.
2:30,
And I'll
please.
grant, I have to grant interim order.
Only till tomorrow. If my lord wishes, only till tomorrow.
No, I'm not, I'll tell the court it may be postponed.
Then counsel for the respondent submits
I'll
that.
tell
They'll
the
not press the
court
matter
to
before
postpone
the,
it tomorrow.
Well,
they'll not press the matter.
My lord, but the order is of the court, my lord, asking me to
Yeah, I
comply.
can tell the court that we are.
Let it be as if it flows from this
What
honorable
is this,
courts.
my lord? I can tell the court
This
that
is
I.
matter tomorrow.
Please, my lord. I'll
Tomorrow
tell the
till
court
such time the trial court shall not precipitate the matter.
Only till tomorrow, my lord, on my.
Till
my
such
side.
time.
Tomorrow.
Only
I
till
said
tomorrow, so that, my lord, they'll
List
keep
this
the same-
matter as first matter tomorrow.
Please, my lord, much obliged.
Bill number 7. Keshav Mohite for petitioner.
Pay for petitioner. I'm furnishing the judgment and decree of. the
Lords,
court.
or if your lordships could have it at 4:30 also, my lords, I'll be here. Is 4:30 all right?
4:30 also becomes difficult because then I cannot inform regarding the compliance. Let it be tomorrow. I will not precipitate further.
Tomorrow is the first case. I'll
First
decide.
matter, please.
Very well. 4:30
I
I'm
will
all
not
right.
seek
Because
any
after
adjournment.
2:30 minutes, I can be here before.
No,
My
no,
lord, I will not seek for
first
any
matter, it
adjournment
will be
tomorrow.
decided itself. I'm not going to adjourn the
I
first
know,
matter.
lords, your lordships are saying.
I will not seek for any.
Lords, all right. So just in case, lords, could your lordships also have my, all right, we'll hand it over tomorrow.
So today if
Yes.
you give me, then tomorrow I will.
Even I am being handed over just in bulks and pieces.
You want to serve him?
We'll serve it across the court. We'll
You can
add
give
on
it-
certain other
You
judgments.
can give it in and tomorrow I'll hear all your judgments.
Because I'll
and
be
I'll look
prepared. I
into-
do not wish to be unprepared tomorrow if they are referring to something.
Give him you'll have the advantage of looking at it.
Please, lords.
Please, much
I am
obliged.
lords, on all these points, I have just stated my argument. Time and again, lords, the courts have said, because I don't want to reiterate or repeat this argument tomorrow. The pendant litter purchaser in violation of order of injunction, lords, he has no voice. That is one. And lords, the Supreme Court has said in a series of cases, lords, that court has the power to
That's why you have to
do good.
tomorrow what you have to convince the court
Yes.
is it the proposition what he is submitting that in a
That,
case of
Manoj, yes, I got it.
specific performance, if pendant,
Does the
during the,
suit
pe-
get
during
frustrated?
the pendency of, during the pendency of the proceedings, if the land is required, even in that case also, cannot,
Yes.
the agreement holder cannot seek for deposit of the
Compensation.
amount, he can only seek for compensation.
Under section 21.
Yes,
One minute.
yes.
If that is the case, how a pendant purchaser is placed in a different
Yes.
position than
Yes, please.
the defendant?
Food for thought, Manoj, I'll just put 2 points.
Tomorrow,
Yes.
tomorrow,
Please,
yes.
much
Agreement
obliged.
still will have to be proved, specific performance granted, only then Manoj I can enter the reference code. For that, the suit will have to go on. So this is something which is very rudimentary. My agreement will have to undergo the
No, now
acid test of a
now
proof.
there is no reference for the reason there is no document in your favor. They have already dealt with the document holders.
Right.
So what, whether you are entitled for that compensation or not. So in that line, I would like to hear you basing
Yes.
on law tomorrow morning.
Please,
Court
much
suits
obliged.
will not be rendered infructuous is what, that is the ultimate point which we have
No,
to.
to start with, that is my view on that.
Much
Whether the
obliged.
suit becomes infructuous.
That's what I'm saying to start with. That is what was my view. He is relying on some judgment.
No, sir, I'll just point out why it is
On
not,
those
why it is
judgments
not.
so
so
that
good.
I'll understand it in a
Yes.
better way. Yes.
Much obliged.
Producing the judgment and decree of the
Hmm.
OS 461 of 2009 as directed by this honorable court in the last hearing.
What is this IA?
IA for impleading application by one of the third party
Hmm.
based on a suit filed by the other respondent.
Come to the impugned order. Let me,
Yes.
so that I'll
Lordship may.
page number.
Page number 61 to 70 is this.
Page number 60.
61 to 70 is the order, my lord. Lordship may kindly see. Yeah.
So objector's application is allowed.
Yes.
What is this? What are these FTP proceedings or arising out of what?
FTP proceedings is in respect of a decree passed by the court in pursuance of the will executed by the grandfather of the petitioners.
Suit for partition.
Suit for partition based on the will, my lord.
Uh,
Will was executed by my grandfather in favor of his grandsons, not in favor of his sons or any children. And in fact, the sons and daughters have partitioned in 2007. That partition was set aside by the court which has passed the decree. Based on the partition, the other respondents have filed a suit for declaration in OS 461 of 2009. That suit came to be dismissed for declaration injunction against the impleading applicant's father, stating that there is a discrepancy in the measurements and he is in possession. According to that, on the basis of the judgment and decree which has been negatived by the court, the present applicant filed an application that I have to be heard and I have to be a party in this.
let's see the order.
Yes. I have produced the judgment and decree what on the
First, let's read the reasoning, then I'll understand what it is.
Yes.
His father was not a party to this.
Which,
His father, implead applicant's father is not a party to this suit.
to my suit, he was not a party because
Your suit is also for partition.
we filed a suit in respect of the property which was given to our grandfather, and his father is one of the brothers of the grandfather who obtained the party his share in 1932 partition. There was a clear partition in 1932 wherein C. Narayana.
What happened to that partition deed?
Partition deed is registered, and based on that, C. Narayana got the khata transferred to his name.
You are saying that it is, that the partition deed is set aside.
Partition deed of 2007 was set aside, my lord.
That earlier one. So according to way back on 1930 itself, there is a partition.
Between the grandfathers and his brothers, my lord. Grandfather got the property under that partition. That property he bequeathed in favor of grandsons.
So now this property belongs to your grandfather.
Yeah, our grandfather, which was bequeathed.
Which fell to his share in 1933 partition.
Yes, my lord. The present applicant's father was also one of the party to the partition. Lordship, and kindly see, they clearly admit.
Case number 461 of 2009 is filed by the implead applicant against whom?
Not by the impleading applicant, my lord.
His father.
Other respondents against the impleading applicant's father, my lord.
Hmm.
I have produced the judgment and decree of the same.
Hmm.
Their claim was based on the partition deed of 2007, which has been.
And this suit scheduled property is in that.
Yeah, yes, my lord. They claimed the same property which they claimed under the partition, my lord, which has been set aside by the judgment and decree of which FDP is filed, my lord. So there is, your lordship may kindly see the judgment and decree which I have produced today of 461 of 09.
The father of the applicant is also one of the party in the said suit and he has contested the suit.
Yes, ma'am.
The presence of applicant is very much required and his rights in the suit properties has to be considered. Now, in this case,
Yes,
what is the case of the plaintiff?
Plaintiff's case is for the partition in pursuance of the
Who are the parties to this?
plaintiff, I mean
Who is the plaintiffs are 4 in number,
yes.
5 in number. What is the relationship between you and the
Plaintiff
plaintiff?
5 in number, they are the persons who partitioned the property in 2007. They are the sons of C. Narayana.
That is your grandfather's brother.
Yes, grandfather, no, my father, our father and his brothers and sisters.
Hmm.
So actually, my lord, what was happened, my lord, my grandfather did not bequeath his property in favor of his sons. He bequeathed this property which he obtained under the partition in favor of his grandsons. Whereas his sons and daughters partitioned the property in spite of this bill in 2007. That was questioned by me in the partition suit. That has been set aside by the trial. And I filed an FDP proceedings against the persons who, the respondents are the persons who got the partition deed, based on which they filed 241 of
That I understood. First suit I understood and the FTP arised.
Yes, ma'am.
I'm asking about the second suit.
Second suit is
The second suit, all the plaintiffs and defendants are belong to which branch?
the plaintiffs were family of the petitioners. Petitioners, grandfathers, they are the father and great uncles of the petitioners.
So this branch,
Yes, ma'am.
they have filed a suit against the other branch.
Other person who supposed to be in possession, he claims to be in possession of some.
So what is the suit that is sought? What is the relief? Let's see.
Yes, my lord. That was the suit for declaration injunction, my lord.
And that property is, the same property is the subject matter.
Yes, ma'am.
So let's see what is the order.
Yes, my lord.
What is the finding on declaration?
Your lordship, kindly see page number 4 of the judgment, my lord, of 461 of 09, my lord.
Yes.
The top, CN Nagesh, CN Chakwan. Further, the said brothers and one Srimati have divided their joint family properties under registered partition deed dated 30/5/2007. Further, plaintiff number is the son of C. Narayana, who is the grandfather of the petitioner. Plaintiff number is son of plaintiff number 1.
What is the suit schedule property
Suit schedule property
of this suit?
of this suit.
So your suit for declaration and mandatory injunction is dismissed.
By
What does it mean?
Yes, my lord. The suit was filed based on the partition deed in which they obtained the property. That partition deed is set aside by the judgment of our honor.
I understand. This is a suit for bare injunction.
No.
It's a suit for declaration and injunction,
Yes.
where the similar suit properties in this and that are one and the same.
Yes, my lord.
In those circumstances, why his presence is not necessary before the court?
Kindly, I take your honor's
So
lordship.
family members have lost a suit.
They are not the family members of our,
You said so.
they are the family members of other brother of my grandfather. Who,
This OS number 461
461, yes,
is filed by whom?
our father and the others, my lord.
Yes, please come. The present petition is filed. Agreed with the order passed on I number 1 in FTP number 19 of 2024, dated 5th February 2026. The trial court, by order impugned, has allowed an IA filed by the applicant under Order 1, Rule 10(2), Read Section 151 CPC. The court observed that the suit OS number 461 of 2009 was filed in respect to the decree scheduled property, and it is not disputed with the petitioner. Further, the decree passed in OS number 461 of 2019 is not challenged and it remains intact. Further, as per the contention of applicant, the dispute in the said suit is in respect of measurement of the suit property, and the father of the applicant is also one of the party in the said suit and he has contested the said suit. When such being the case, the presence of applicant is very much required and his rights in the suit property has to be considered. If the application is not allowed, definitely it leads to multiplicity of proceedings. If the application is allowed, no harm or injury would cause to the petitioner. Further, if the applicant is impleaded, the petition can be adjudicated effectively. Therefore, the application deserves to be allowed. Accordingly, the court has allowed the application. Learned counsel appearing for the petitioner submits that the implead applicant does not belong to the branch of the petitioner. In fact, the implead applicant's grandfather and the petitioner's grandfather long back has divided the properties in the year 1933. 32. And basing on that, basing on the said property fell to his share, grandfather executed a will. In that regard, the present suit is filed and the suit is decreed, and in the FTP proceedings is not a necessary party, and the court, without considering the contentions raised with the petitioner, has dismissed the same. Hence, the order impugned needs to be set aside. Next, having heard the learned counsel for the petitioner, peruse the material on record. The earlier the suit that is OS number
48 of 2014.
OS number 461 of 2009 is filed seeking declaration and mandatory injunction. That said suit, the suit scheduled properties are one and the same. The suit filed by them is dismissed by the court. The plaintiffs therein are the members of this branch, petitioner's branch, where his father is also one of the plaintiffs. That judgment and decree has attained finality as they have not questioned the same. The court has rightly come to the conclusion that the impleading applicant is a proper his presence is necessary to decide the dispute, and if not, it would lead to a multiplicity of proceedings. In the considered opinion of the court, there is no illegality with the order impugned. Accordingly, the writ petition is dismissed.
Bill number 8, Gopal Singh for petitioner.
Possible petitioner warrants. Notice may be issued. This case is upon an application of impleading application, my lords.
Notice.
Bill number 9. Banu Prakash, party in person.
No representation list in the month of October. Give some date. Yes.
Cell number 10. Cell number 10 is Rajshekar.
It's appearing for petitioner. And it's the suit is for.
Yes. Yes.
It's a very short point involved in this case is, my lords, sir, there was an order of attachment, my lords, before judgment. The suit is one for recovery of money. Lords, I had offered my property as security.
Lords, under changed circumstances, my lords, I sought for my lords release of my property with the direction to the defendant to furnish some other property as security. For the simple reason, my lords, the defendant was my son-in-law. Lords, so there was a dispute with the family of my lords, my daughter and my lords, my son-in-law. So I thought, my lords, let me not, my lords, offer my property as a surety to this particular property, this particular loan. The liability is 14 lakhs. My application came to be rejected on the ground that, my lords, this property, kindly see the reasons assigned by the, my lords, the trial judge.
No, under which provision you can do all this?
Lords, now
Why did you come up, why did you give your property as a surety in an application file?
the property of the defendant was, my lords, sought to be, my lords, attached. I was, my lords, I had offered, my lords, this particular property as, my lords, surety to that particular loan, thinking that, my lords, my son-in-law would sell that property and, my lords, clear the outstanding amount. Subsequently, my lords, there was
a notice for
please.
this correspondence. Yes, next.
Cell number 11. Nitish.
No, notice hand summons. Yes.
Obliged.
Yes, 11.
Cell number 12. Cell number 12. Manoj.
Notice.
Cell number 13.
Lords,
Nagesh, yes.
it's a plaintiff petition, my lord. Initially, the plaintiff filed a suit for bare injunction against defendant, which came to be dismissed. Against that order, he preferred an appeal, which came to be allowed. Against that allowed judgment, the defendant has preferred RSA before this honorable court, wherein he filed an application under order 41 rule 27 to produce certain documents. At the very same time, plaintiff was supposed to be produce some documents. Therefore, that appeal came to be allowed on 24/4/2025, and matter has been remanded to the trial court and given liberty to both parties to adduce evidence as well as documents. My lords, after remand the matter, we have immediately after remanding the matter, we have filed an application under order 6 rule 17, because there is no pleadings regarding the documents which we are going to produce as per the direction of this honorable court. To that effect, we have filed an application because all pleadings contained subsequent to judgment and decree passed by trial court as well as appellate court.
Come to the order.
My lords. Annexure A is the order, my lord. The reasoning given in page number 19, my lord. Para 9, McLean.
Yes.
My lords, para number 9. From the reading of the above provision, it is clear that before commencement of
No. Before that, we'll go to your IA.
my lords,
IA.
page number 98, make kindly, please. Annexure H. We have mentioned clearly regarding RSA, the application filed by the defendant order.
There is amendment application.
That is the application. This is the application.
Page number?
Page number 98, my lords.
This is not the application. I'm asking for the affidavit in support of the
Affidavit, my lords. They filed in the rural. This is the affidavit. In the affidavit, it is stated that in the High Court, they filed the application under 41 rule 27, and court granted liberty to adduce evidence to both parties. So accordingly, this application filed with a small affidavit, my lords.
No, let us look at your, what is the amendment that you are seeking?
My lords, page number 98. Para 3 may kindly peruse, my lord. It is submitted that submitted by the plaintiff that during the pendency of RSA 422 of 19 before the Honorable High Court of Karnataka, the defendant herein has filed an IA under order 41 rule 27, read with section 151 of CPC, along with some documents to lead additional evidence. Hence, the Honorable High Court of Karnataka has remanded the matter to this Honorable Court by taking the said documents on record with liberty to parties to lead further evidence on additional documents without adjudicating on merits of the case. In this regard, it is pertinent to note that as against the alleged endorsement issued by the Tahsildar Mysore, Taluk and produced before the Honorable High Court of Karnataka.
Sure.
Suit for bare injunction, madam.
Hmm.
We have tried to make all pleadings subsequent to.
Please come to the paragraph number 13.
My lords, paragraph number 30 of.
Yes, please come and comes for the petition submits that. After the matter is remanded and after the matter is remanded, they file the present application seeking under order 6 rule 17, seeking amendment of the plaint. It is submitted that all these aspects, all these aspects which they want to bring to the notice of the court are subsequent to the decree of the suit, and when the matter is pending before the appellate court. In fact, they have filed an application under order 41 rule 27, which came to be allowed, and the matter is remanded, and all these aspects were not appreciated by the court. Considering the same, there shall be stay of all further proceedings.
Right.
Notice. Yes, next.
Sale number 14, 18B.
No representation in the month of October.
Sale number 15, HM Madhusudan.
Okay.
Sale number 16, Anirudh.
Preparing for the petition. Lord, this petition, my lord, is against the order passed on an application filed under 21 rule 26, my lord. My lord, here, my lord, originally, my lord, the suit was for cancellation of lease deed and recovery of rent arrears and men's profit, my lord. My lord, summons, admittedly, my lord, summons was served to me.
Come to the impugned order, page number.
Please, my lord, page number 32, my lord. My lord, the reason assigned to, my lord, in the.
Let's read it. Let's read.
Please. Relevant at page number 34, my lord. Paragraph number 9, my lord.
Let's read.
Paragraph number 9, my lord. Further, it is pertinent to note that after judgment and decree passed by this court in OS number 13 of 23 dated so and so, the defendant has not filed any appeal against the said judgment and decree. Moreover, when this court has issued attachment of movable properties of the JDR and arrest warrants against JDR, then only he has come up with this application for stay of execution of the petition. Further, in their affidavit, they have stated they had suffered a major health issues and he has suffered brain so far as he has bedridden for several months. My lord, here, my lord, ex parte decree came to be passed.
Completed.
Several months, though he suffered from cardiac arrest, therefore underwent treatment at so and so hospital at Calicut.
Where are the documents to show your ill health?
My lord, here, my lord, I have filed this application on the ground that I have filed a miscellaneous petition before the same court seeking to set aside the ex parte decree passed against me, my lord. My lord, here, my lord, the suit, my lord, is instituted before the Honorable Senior Civil Judge, my lord. Whereas, my lord, the nature of the dispute is commercial in nature, my lord. The lease deed itself, my lord, I have produced, my lord.
Whatever it is, when you're saying something in support of your IA, are you not supposed to place all the documents?
Please, my lord,
You say that you have serious health conditions. You don't even place one document before the court.
My lord, if I may draw my lord's attention to my application, my lord, the affidavit, my lord, at page number 78, my lord. Annexure G, my lord.
Yes.
At paragraph number 4, my lord. My main contention is here, my lord. I have also filed a petition before this honorable court under order 9 rule 13 of CPC seeking to set aside the
Yes,
judgment.
where are the documents? That's what the court asked you. You couldn't get an order in the miscellaneous. Your remedy is to get an order in the miscellaneous, not in the execution.
Lord,
in your execution, you have filed a petition. At least one document in support of your case.
My lord, I have filed miscellaneous petition, my lord, that is before the honorable court, my lord. My lord, if I may draw my lord's attention to the order 21, my lord, it empowers me to, my lord, if the executing court to grant stay, if this
provided you place some material before the court, not just like that.
My lord, here, my lord, the lease deed has been cancelled, my lord, by the order of the honorable court. The advance amount which I had earlier paid, my lord, that also has been not.
So the matter, I'm not going to decide your miscellaneous petition.
Please, Lord, now, my lord,
I am only on the point about the legality or the illegality of this order. What is wrong with this order?
My lord, here, my lord, This, my lord, on the ground of that I have filed a miscellaneous petition seeking to,
That cannot be a ground at all.
my lord, the order, if I may, my lord, if I may
If
please
it
read.
says that it always speaks about a reasonable ground and the discretion of the court.
Please, my lord.
Why should the
Reasonable
court be, why should the court be satisfied with anything, everything you say?
My lord, in miscellaneous, I had produced all the documents, my lord. In here, my lord, I have not produced. Admittedly, I have not produced, my lord. But in miscellaneous petition, I have produced
So when your
all the
execution
reasons.
comes,
Please, my
court has to call for the miscellaneous case.
My apologies, my lord. My lord, on this ground, my lord, assuming, my lord, the order 21 rule 26.
File before this court will see.
My lord, if I may, my lord, if I may seek, seek for a passover, my lord, if I
Yes,
may.
passover.
Grateful.
Then number 17, Girish Anna for petitioner.
My lord, the suit is one for specific performance, my lord. The plaintiffs before the trial court have filed this writ petition. Lord, the trial court impounded the agreement of sale, saying that it is insufficiently stamped. And instead of invoking section 34 and imposing penalty thereon, the trial court refers the document to the district registrar. My lord, upon referring the document to district registrar says that 57,000 is the deficit amount. So once the district registrar decides, my lord, the trial court imposes 10 times penalty. What happens is, once the document is impounded under section 33, the court has to invoke section 34. Instead of invoking section 34 of imposing penalty, if the document is sent to the district registrar, then it is left to the discretion of the district registrar to adjudicate the amount payable. After district registrar takes a decision, the trial court cannot impose 10 times penalty. That is the decision rendered by the Honorable Supreme Court. May I just pass?
Why do you want to go to the
Yes, yes.
judgments?
Lord, this
No.
aspect was brought to the notice.
No, please understand. Now the court has, the district registrar, he would be calculating it along with the penalty.
Yes, my lord. He said 57,000 is the deficit and one-time penalty has to be imposed. Subsequent to the report of the district registrar, the trial court proceeds further and imposes 10 times penalty, which is impermissible because the Honorable Supreme Court says once the document is impounded under section 33, the court has to exercise power under section 34. If the document is sent to the district registrar,
Now,
section 39 becomes applicable.
for this procedural irregularity, whether the district registrar's order is correct?
Adjudication is correct so far as deficit is concerned.
As far as penalty,
Penalty, the same amount. Deficit plus one time the deficit amount is the penalty.
then why did the court impose 10 times?
10 times, my lord, contrary to the ruling of the Honorable Supreme Court.
Come to the order.
Yes, my lord. Kindly see, my lord, page 20.
Page?
20.
Hmm.
Plaintiff number 4 present. Counsel for the plaintiff number 4 files examination in chief affidavit. He examined as PW1 and got marked documents as exhibit P1 to 3 and pray time granted. For further chief of PW1, perused agreement of sale dated 26/8/2004 is insufficiently stamped. Therefore, as per judgment of the Honorable Supreme Court of India in case of Sitaram Shetty, the said instrument is to be sent to the district registrar for calculation of deficit stamp duty and penalty.
Where is the next order?
Next order is at page number 25, my lord. I'm sorry, 22, my lord, 22. Received the report of district registrar. As per the report,
No, it's not correct. I think the page number is something wrong.
my lord, very next page, my lord, very next page in the order sheet.
The order which you read now
Yes, my lord.
is dated 24, page number 24.
20. I'm sorry, my lord, if there is.
Oh, yes, this is the report. It is a 25.
Yes, my lord. Received the report of district registrar. As per the report, rupees 57,000 is the stamp duty to the instrument dated 26/8/2004. That is the agreement of sale with possession. A perusal of the agreement of sale dated 26/8/2004. The said agreement of sale reduced rupees 2 paper sheets. They have obtained stamp papers of rupees 6. Therefore, there is deficit duty of rupees 56,994. Therefore, plaintiff has to pay one-time deficit of rupees 56,994 and 10 times of penalty of rupees 56,940.
Come to that, come to the report of the district.
Lord, the
registrar.
report is next page, next page document, my lord.
Hmm.
On the second page of the document. Last 5 lines from the bottom, my lord. 8%, rupees 57,000. That is the adjudication made by the district registrar. Once it is referred to the district registrar, the court cannot go back and impose 10 times penalty. May I just pass on one judgment, my lord, which is directly on the point.
It has imposed 10-time penalty on what basis? That's what I'm asking.
The court has invoked section 34, where the court is empowered to impose 10 times penalty if it impounds a document and comes to a conclusion that document is insufficiently stamped. Instead of imposing penalty upon noticing the insufficiency, the document is sent to the district registrar. Therefore, the trial court has bypassed section 34. Once that is done.
No, for example, he will come up with some calculation. You are agreed by it. Then what you will do?
Well, then the court can summon the market value documents from the sub-registrar office and do it.
Till the discretion is, no, it's a matter of the revenue.
Yes, well, what the trial court has to do is, it has to impose penalty by noticing what is the deficiency and send a certificate to the district registrar under section 37. Then the district registrar will look into the certificate and tell the court whether it is right or wrong, upon which the trial court finalizes the imposition of penalty. Here, the trial court sent it to the district registrar. District registrar gives a finding.
What is the deficit stamp duty to be paid?
Yes, my lord.
That is he has sent it.
Well,
No, when an order of the authority on your objections, when the court can again review that order, why not this?
Well, there is no dispute regarding the adjudication amount. 57,000, I have no dispute. I am ready.
Generally, what would be the amount that the court will charge as penalty?
Well, the court, if it impounds and adjudicates there itself, it imposes 10 times. If it relies on the report of the district registrar, it has to be 1 time.
Somehow, I don't.
Now, what happens is,
Let's see the Supreme Court
Yes,
judgment.
yes,
I'm not able to understand that, I'm not convinced with that logic at all.
Yes.
It is ultimately what you have to pay, you have to pay. That is generally in all the cases, they impose 10 times penalty.
So far as deficit is concerned, I'm ready to pay, my lord. So far as imposition of 10 times is concerned, I have objections. Because after the district, yes, my lord. Currently, see, my lord, the relevant paragraph I've highlighted at para number 22, last but one page. The trial court is yet to exercise its jurisdiction under section 34 of the Act. On the contrary, the trial
Paragraph number
22.
23.
22. I've marked the relevant portion. The trial court is yet to exercise its jurisdiction under section 34 of the Act. On the contrary, the trial court has called for a report from the district registrar. So far, all purposes, that suit instrument is still at 1 or the other steps summed up in para number 21. Therefore, going by the request of the respondent, the option is left for the decision of the district registrar. Contrary to these admitted circumstances, though the suit instrument is insufficiently stamped, still the penalty of 10 times under section 34 of the Act is imposed through the impugned orders. The imposition of penalty of 10 times.
Any other judgment? Any other judgment?
This is the latest position, Miller. This judgment was brought to the notice of the trial court. In fact, in the impugned order, it is referred, but this aspect has not been noticed. Therefore, the matter requires consideration. Because what happens, 57,000 I am prepared to pay. If the trial court order is confirmed, that would amount to 10 times, my lord, it will run into lakhs. Therefore, my lord, if
the court has to decide the deficit stamp duty, it would be 1 lakh.
The court cannot decide. The court has to either impound and adjudicate.
For impounding and 10 time penalty is a general order.
Yes.
What would be the amount that will be decided by the registrar?
Yes. But here the registrar has given a specific figure, whereas this is the amount imposed to be imposed. And upon receipt of the report, the court should have said, you pay this amount with penalty. Instead of saying so, the court imposes 10 times, which is contrary to this.
We'll see. There must be some other judgments.
Look, this is the latest one, my lord. This is the latest one.
This is smarter day after tomorrow. Somehow I'm not convinced with that. Well, there must be other judgments.
Yes.
Contrary.
Cell number 18. P.S. Nagaraj.
I appear for the petitioner, madam. This is the defendant's writ petition.
Yes.
Respondent plaintiff filed the suit for permanent injunction. Respondent number filed the suit for permanent injunction. This defendant is also filed the injunction. He has also obtained temporary injunction. The survey number suit scheduled property is survey number 189. It is totally measures 50 acres. Just adjacent to this land, the defendant's land is also there. And there is no specific identification of the land of the plaintiff and defendant. But defendant is also obtained temporary injunction at Annexure D.
We'll see the day you please come. I'm not able to follow. Yes, this is matter day after tomorrow. Yes, next.
Bill number 19.
Lord, for the petitioner, my lord. Plaintiff's petition, suit for partition and separate possession. Trial is yet to commence. 6 Rule 17 application was filed seeking amendment of pleadings.
What is the suit for?
Partition and separate possession.
Suit of the year?
2008. Issues were framed in 25 only.
2008.
Yes. Suit is of the year 2000.
Come to your IA, let's see.
Please. Lord, page 63 is the affidavit filed along with the page 63, my lord. Paragraph 3, may I read, my lord?
You are the purchaser.
No, I am the.
What is this affidavit I'm reading at 63?
63 is by the plaintiff, my lord.
I state that we have come on record in the present suit in the year 2013.
No. These people were LRs. Original plaintiff is the wife.
Oh,
as
yes.
such.
Mm.
I state that subsequently my wife on further information had filed application to include properties, that is item 11 to 24 of suit schedule properties, and also got implicated several purchasers of items number 5 and 4 in suit schedule property. I state that we had come
Those
on.
were framed in the year 2022.
Right, please, my lord. Next page, my lord, may kindly come. Additional issues were framed on 15/9/25, paragraph 5. Trial is yet to commence. The trial court also come to such conclusion that trial is yet to commence. What the court says is these are not necessary to decide the.
No, come to paragraph number 6. What is that you want to
I
amend?
said that recently while preparing for affidavit, we noticed that the registered documents are produced while consideration of application for temporary injunction before this honorable court, along with the application seeking production and also before the honorable high court in appeal number so and so by defendants 1 to 3, and also felt necessary to incorporate the said documents.
What
in
are
the
those documents?
sale deeds, my lord. Sale deeds of suit schedule properties where they are transacted, income is received from that. Out of that, item numbers 11 to 24 are purchased in the individual names of the co-partners. That is the entire case, my lord. There are certain properties, item 1 to 10 were included in the suit.
No, it is your affidavit. Your affidavit itself runs into 17 pages.
Like that, to give details with regard to the sales.
So those many things you want to do, which were available for you.
Well, that is only.
And you don't even give the dates of these documents. Nothing.
Well, that is given in the amendment. Amendment application. My lord will get at page 59, my lord. Specific with regard to item numbers itself. Paragraph 10A, what I wanted to, the proposed amendment.
Registered sale is
Please.
dated 6/3/1996. The suit is of the year 2009.
2008, my lord.
By that time, everything is available to you.
Well, it was available. That's the reason.
19/8/1996, 2/5/1996, 26/4/2000,
Lord,
22/2006.
the sale proceeds of these properties are or purchase.
So there are no pleadings to this effect. Now you want to take a different stand.
No. My lord, pleadings are already there to say that these
What
are
was your pleading?
joint family properties, what we have already said.
Hmm.
In the plaint, we have already said.
No, by placing this document,
Please.
what you want to establish?
I want to establish that these properties after sale, the sale proceeds, out of the sale proceeds, item number 11 to 24 are purchased.
Come to the order.
Please. My lord, the reasoning starts at page 22. May I read paragraph 8, my lord?
Yes.
Though issues have already been framed, the evidence has not yet commenced. Therefore, the proviso to order 6 Rule 17 of the code is not attracted and plaintiffs are not required. At page 22, my lord.
No, you can come to
Please.
The
main object. Okay.
Yes.
Paragraph 10, my lord, page 24. The plaintiffs also seeks to introduce pleadings regarding earlier sale deed.
Then calls for the petitioner submits that suit of the year 2008, and even as per the order passed by the court. The issues have already framed. The evidence has not yet commenced. It is submitted that they have to, by way of this amendment, they want to incorporate certain pleadings pertaining to the properties that were sold, and basing on that, the other properties, after selling out of the sale proceeds, the other properties are purchased. He submits that. The plaintiff is not taking any contrast stand, and in support of their pleadings, they want to file these documents by way of this amendment, by taking pleadings and file the documents, and the court has failed to consider the same. Considering the submission, there shall be stay notice to the respondents. Hand summons.
Cell number
Public.
20, Sampath
For all
Kumar
these
Reddy.
hand summons, give the date as 1st of September. Yes.
There are only two defendants had filed objections. Defendant number 1 and 3 had filed objections. Others, they didn't object this application. May I take notice only to those?
Is respondent number?
Is respondent 1 to 5, my lord. They are respondents 1 to 5.
Respondent 1, notice to respondent number 1 to 5, then dispensation to
6 to 22, my lord.
6 to 22, a memo is filed. Please give the memo.
I will.
Seeking dispensation, dispense with. Yes, next.
Cell number 20,
6 to 33, my lord.
6 to 33.
33.
Give the
Please.
memo.
Please.
As I appear for petitioner.
Hmm.
It's a suit for bare injunction minutes filed by each other minutes. In the connected matter minutes, already there was a status quo order.
Where is that order?
Status quo order was passed in the
Where
order.
is that? Have you?
Page number 63 minutes.
60?
63, annexure G. It may be tagged along with that appeal, that writ petition.
It's a 21/4/2026 order.
Please, minutes.
Whose suit is this?
Minutes, that is a suit filed by.
You are the plaintiff?
Please, minutes. There was
Both the suits?
Both the, oh, no. In one suit, my lord, for the first instance, I filed a suit against the respondents. In that, my lord, a status quo order was
So
granted.
this order of stay is whose suit? Your suit or the other side's suit?
My suit, my lord. My
So
suit.
this is?
This is filed by respondent number 1.
Then counsel for the petitioner submits are. There are two suits against each other seeking the relief of bare injunction. In petition, questioning an order or refusing injunction, the petitioner has filed WP number
12086 of 26.
12086 of 2026, and a coordinate bench of this court by order dated 21/4/2026 has granted an order of status quo. Now this order arises out of an appeal, miscellaneous appeal in the suit filed by the respondent.
Please.
In the light of the status quo order granted by the court, the same shall continue. In this case also, there shall be an order of status quo. Same, hand summons notice.
Deeply obliged.
Cell number 21, Sanjay H. Setia.
For the petitioner, please, Muladza. That's in this matter. Muladza, actually, the writ petition, Muladza, is challenging the order of the trial court on an IA seeking recall and reopen Muladza at annexure A. 24th March 2026 order, please, Muladza, I have challenged. Muladza, what has happened in this, by the time, Muladza, I could apply and get the order copy, the evidence stage again, which was recalled, got closed, please, Muladza. I challenged the order before this honorable court on the 24th of July.
So it worked out. And after that, court has reopened.
Court has allowed it, Muladza. What has happened? I filed 3 applications: recall, reopen, and to discard the evidence of the previous witness which I had led in, because he had left the services of the company. Thereafter, what has happened, Muladza? The order copy has not come. I failed to appear because I did not have the order copy. What to comply, I did not know. The court had closed the stage of the evidence. Now, Muladza, tomorrow is the matter. I am at the stage where, Muladza, actually my got allowed, but in the order, online status was not correctly, all the contents of the order was there. I wasn't aware of that. I had to lead evidence on the next date of hearing. I missed the matter, Muladza. Only 2 documents that are, Muladza, only 2 documents.
Because we can't know that already the train has left the station.
I understand, Muladza. What has happened is,
You have to go to the next station. And we can't pass any orders on this.
no, Muladza, if I maybe, I'll withdraw this writ petition, please, Muladza. I will not press upon, because I genuinely, Muladza, I've lost the stage. Only request is that, Muladza, if I make an application, the trial court maybe consider my application of recall one more time, please, Muladza. That is all. The liberty may be.
It would send a wrong signal.
My lords,
I will
liberty,
say-
my lords.
I will say whatever is available to you, you will pursue.
Liberty,
Land
liberty.
counsel for the petitioners of this, sir. The present writ petition is filed questioning
Order dated 24th March 2026.
which is in your favor. As the online status of the order was not clear, the petitioner has questioned an order which is in favor. Thereafter, the court has reopened the case, and as there was no representation on behalf of the petitioner, again the state is, so the stage is closed now, and the matter is posted for
Arguments, final
matter
arguments.
is posted for arguments. It is submitted that the petitioner, but as nothing survives and the order is in his favor, he may be permitted to withdraw, and liberty may be given to pursue the remedies available to him. Accordingly, the writ petition is dismissed. Accordingly, the writ petition is disposed of, giving liberty to the petitioner to avail the appropriate remedies. Your
Much
client is in a haste to come to High Court, whatever is the order.
In fact, he got panicked, my lords, thinking that the evidences have been closed and he was not given. In fact, what happened, my lords, 2 IAs got allowed. IA to recall the witness was allowed. However, the second IA, my lords, was rejected. The only rejected word is uploaded. In fact, they have given liberty with rejection, which is what we could not see, my lords. After the order copy came, we saw by then the stage got closed. Please, my lords.
One more last matter on this page.
Serial number 22. Guru Raj, please tell me.
This case is arising out of a compromise petition entered into between Plenty Fund defendant number 2. Whereas we are for defendant number 4 to 13. Keeping us under dark, they enter into compromise petition as per annexure C. Madam. Compromise petition under order 23 rule 3
what is impugned
filed
now?
by the. Madam, we are the investment.
What is
investors.
the impugned order? Impugned order.
Impugned order, my lord. Page 61, annexure E. Page 70, my lord. It is ordered and decreed that suit filed by the plaintiff is decreed in terms of compromise petition filed by Plenty Fund defendant number 1.
This is the impugned order.
Yes, ma'am. Whereas I am 4 to 13 before the trial court. We are not at all part and parcel of that compromise petition.
This decree is passed by the court.
Their lordship may kindly see page 44, my lord, compromise petition filed by the plaintiff and defendant number 2. It is very clear.
How can this court will compromise the decree?
Suit is still pending, my lord. We have filed application. We have filed our objection as per annexure D, page 54. Court has not considered our objections.
So this court will set aside the compromise. Where is the impugned order? That is what I am asking. If a
Impugned-
judgment and decree is passed,
Yes, madam.
what the court, what this court is going to do on that? That I am not able to understand.
Yes, madam.
If a judgment and decree is passed, you are agreed, you are a party to the, you are not a party to the compromise.
No, we are not at all party.
Then what you are supposed to do, you should file a writ petition before this court.
It affects our right. We are investors. Plaintiff is a landowner. Defendant 1 and 2 are developers. We have invested money. Without making us as a party to the proceedings in the compromise petition, they want to settle this.
Remedy is not filing the writ petition. I think I don't have to advise you that.
Well, previously it was posted before Portal 10 as categorized it as a GM. Again, we have requested, case is pending.
Show me the provision of law under which this court will interfere with this. We are not saying CPC is not.
Yes.
You show me a provision of law under which this court is going to interfere with a compromise decree on the ground that you are not a party.
Kindly up next week.
Yes, next week.
Lords,
Done?
Your Lordship's kind permission. Number two, one submission. Serial number 34 is urgent, madam. May I kindly take up at 2:30, madam.
What is urgent?
There the matter is take up for the evidence and cross examination also.
When was the
WS is taken as not filed.
writ petition filed?
WS is not,
Writ petition is filed when?
it is filed about 2 months back.
Then what happened to that?
The matter is listed on in the second list, madam, in the second list, madam.
That is for objections.
Yes, madam.
Don't comply with the with the writ petition from the last 2 years, and I should take it up at 2:30. No.
Bill number 82, my lords, it was listed on Friday. Since the respondent was on caveat, we had undertaken to file a serve a copy, and your lordship had posted it today. Is that serial number 82, my lords? We have served a copy. There's some urgency, my lords.
Yes, that too.
Your Lordship, serial number 8 in the second list. I am appearing for last too many times. It is not even reaching. Thereby, this is actually cancellation of a joint agreement. Position is claiming anything and is making so many criminal petitions about me. Thereby, this may be heard either in the afternoon or by tomorrow by first list. So tomorrow.
Serial number 59, Lords.
No, this is not reached.
It will not reach because I can't
Yes,
do
by
those many
3 times,
matters. There are so many, please
Maybe at
understand
least
the
by
council.
tomorrow even.
There are so many matters, I can't take that kind
So
of an
many,
exception.
at least by
Yes.
tomorrow too.
Yes, no.
Serial number 59, Lords, FDP execution proceedings, delivery warrant has been issued. This honorable court had granted an interim order. The petitioner has filed an extension of interim order because on the last date of hearing, the council on record had filed a retirement memo without particulars. We filed an extension of interim order application, my lord.
So that.
Please.
Tell me, sir. 59 and 82 ಎರಡು.
Madam, ಮಧ್ಯಾಹ್ನ first one continue ಮಾಡ್ತಿರಲ್ಲ?
Sir?
Next one continue ಮಾಡ್ತಿರಲ್ಲ? Sorry, madam. List number 2, early morning, engage. List number 2, serial number 13. Needful done, my lord. No, stay maybe. List number 2, sorry, early morning.
Needful done, stay should be granted.
Yes, yes.
What is that?
I'm going to myself to personally.
No, without hearing the matter, why will I grant stay?
Stay already granted.
And then?
Needful done, a person income is going to hospital. Request by the son.
No, it's a case where already stay is granted and you are directed to take hand summons.
And someone's already served.
Which is that?
List number 2, serial number 30. Serial number 30.
Will encounter the petition submits such as per the order passed by this court. He has taken out hand summons. Interim order earlier granted is extended. This is matter on 6th of October.
Number 26 and list number 2. This matter is taken up, it may be disposed of. That petition becomes infectious.
No, again, we start this mentioning process. It won't go anywhere. Please call the list. We'll see later. Just call the list. Continuation.
List 1, serial number 23, AG Nagaraja for petitioner.
Please, my lord. The plaintiff's writ petition and writ of mandamus directing the trial court to dispose of the pending applications as well as to conclude the trial as possible as earlier. Because of the suit of the year 2018, please, my lord, filed for the relief of declaration and filed by my father.
Which court is this?
This the civil judge, senior civil judge at Vascote, please, my lord. Now the pending applications, in view of the pending applications, the proceedings will not be continued. Please.
IA number under order 39 rule 2A CPC.
Please, my lord.
Filed under order 7 rule 11A.
Please, 2 applications have been filed. One is filed by the defendant number 1, 7 rule 11 application for rejection applied. It is of the year 2024 filed by the defendant number.
Please come. Suit, I will not say anything.
And another application, your lordship
Yes,
may kindly see
the writ petition is filed seeking the following prayers. When comes for the petitioner submits that there are 2 applications pending, one filed by the plaintiff and the other filed by the defendant, and they are pending from the last more than 4 years. Considering the submission of the land counsel for the petitioner and considering the fact that this is that these are all the old IAs, this court is passing the following order. So and so it's disposed of, directing the court dispose of both the application within a period of 8 weeks from the date of receipt of the
and the
copy.
next date of hearing is in the 20th of this month, please, my lord.
Let it come 8 weeks, I said.
And one more submission, please. And because of my father has filed a suit and my father died without getting the justice. And I am the 3 brothers have been implicated as a parties, please, my lord. And one of the 3 brothers were residing at outside India. And who is contesting the case, please, my lord, is suffering from vascular disease. And that's why I am requesting before this on court, please, my lord, as possible as 8 years of the suit has been completed now.
Yes.
Serial number 24, SV Prakash for petitioner.
Challenging the concurrent finding on the temporary injunction.
Come to the appellate court's order.
Page number 143, my lords.
143.
3. I instituted a suit against the respondents alleging that I am the auction purchaser of.
Well, let me understand it from the order. Please come to the operative portion of the order. I mean, the reasoning part of the order.
Please, my lord. The relevant portion is at page number.
Let's read from para 14.
Para 29 may be relevant, my lord. 166, my lord.
No, I'll understand the facts.
Please, my lord. May I read, my lord?
They have sought for a counterclaim.
Please, my lord. They claim that they are in the possession of they claim
From
under adverse
1996.
possession. Their suit is pending consideration. But my claim is that, my lords, I am the auction purchaser. The respondents are the persons who are claiming under the judgment debtor. They claim they are the coolies under judgment debtor and they are in possession of the land. Their suit is pending, claimed under adverse possession. Initially they filed a suit for permanent injunction which came to be dismissed for non-prosecution.
Whether they claim against the judgment, being in possession of the property by virtue of the permission given by the judgment debtor and all different aspects. You are seeking injunction.
Please.
You have to prima facie show that you are in possession of the property.
Please.
But you couldn't show it.
My lords, I'll convince my lords. As per
I'll read the order. I'll read the order.
Please. My lords, the trial court and the appellate court held that I have not produced any document to show that I was put in possession of the land. My lords. In fact, as
Come
per
to para 20, read it.
20, my lords. Therefore, appraisal of the materials presented indicate that both parties involved in the suit are asserting their claim to possession of the suit property. The plaintiff asserts possession based on the sale certificate, while the defendant contends that they have been in possession since 1966. Learned counsel for the plaintiff has argued out that in OS number so and so, the court of learned so and so rejected the application submitted by the plaintiff in that case, currently defendant number 1, which sought to abstain the bank authority from conducting the auction sale scheduled for so and so. Appraisal of the order passed by the learned so and so court, Shimoga and OS number so and so on so and so, reveals that the application filed by the plaintiff in that case was indeed rejected. This suit was instituted against the DCC bank.
When was the sale certificate?
I have produced it annexure A.
Date.
Sale certificate. 28/3/2024.
28/3/2024. Suit is filed in the year 2025.
Please, my lords. My lords, and as per rule 38(7) of the cooperative society rules, there is no necessity for the recovery officer to issue separate order to put me in possession, my lords, because the sale certificate itself is the conclusive proof, my lords. Kindly see order 30, rule 38(7) of the Karnataka cooperative rules, my lords. Unless the judgment debtor.
You are seeking relief before the civil court. You are seeking relief before the civil court, a suit for injunction, restraining them from interfering with your property. For that, you have to prove your possession.
But the trial court says you have not produced any document to show that you was put in possession, my lord. That's the difficulty. And my lords, unless the judgment debtor obstructed to my possession, there is no necessity for the recovery officer to pass separate order, my lords. And in fact, the recovery of
it is not about all the legality of those proceedings. As on the date of the filing of the suit, are you in possession of the property?
Please, my lord.
You have to show some document, not your confirmation.
My lord, mutation is in my favor. RTC is in my favor.
When was the mutation in your favor? What are the documents filed by
B,
them?
my lords.
What are the documents filed by them?
They have not produced anything. Kindly see the order at annexure.
Yes, that's why we continue to read this order. We'll understand what is informative with this.
Page number 78.
We'll read this. Para 22, you read.
Please, Mr. The learned counsel for the plaintiff further argues that the defendants cannot assert their possession of the agricultural land specified in the suit schedule merely by presenting a residential confirmation certificate without first demonstrating how they obtained possession of the property. It is indeed true that documents such as a residential certificate are insufficient to establish possession of a property of agricultural land. Nevertheless, as argued by the learned counsel for the defendants, these are documents serve to indicate that the defendants are permanent residents of Anupinakatte village, countering the plaintiff's claim that the defendants are merely agricultural laborers working in the village during the farming season. The learned counsel for the plaintiff further contended that the RTC is in fact in the name of plaintiff. He argued that the trial court should have noticed that the grant certificate was issued in the standard format and that possession was delivered in accordance with it, as demonstrated by the RTC extract and the mutation register extract presented before the court. In decision so and so, the order passed by the land tribunal was challenged by the same was remitted to the appellate authority by Honorable High Court. After considering the matter, the appellate authority found that the entry in Pahani showed the land to be fallow during the period of 1963 to 1973. If so, the electricity bills produced by the petition for having used power to irrigate the land were unreliable. The appellate authority found that during relevant period, the owner was a revenue inspector and thus had sufficient influence to get the requisite entries made in the revenue records. Appellate authority found that there are no basis for the alterations made in record rights in favor of the said owner. For the year 1972, 1972, 73, the Honorable High Court has held that the order passed by the appellate authority is not illegal. In this case, the Honorable High Court has held that so and so. Let's kindly see para number 29, relevant portion, page number 166.
Para 29. At this stage, prima facie, there are no documents to show that the plaintiff is having possession of the suit scheduled property. A detailed trial is essential to reach a conclusion regarding the subject matter of the suit.
Please.
What are the documents you wanted to file under order for 41 Rule 27?
The sales certificate and RTC. Sales certificate and RTC. Mutation register in my favor.
From their side, no document is
No
filed.
document. Kindly see page number 84, my lord. This is the order passed in an earlier suit filed by the respondent.
That the court has appreciated that that order is not passed on any
Yes, my lord.
order on the
In
merits
that
of
there is
it.
specific observation. They have no document to show.
What
that.
is what are what is their case? Come to that their objections or where are they? They filed the written statement.
Please, my lord. They filed the written statement.
We'll go to the IA objections. Are you
Please,
have you
please.
filed?
They have filed, my lord.
Where is that?
Page number 55, my lord. Annexure G. 55, my lord. May I read, my lord? It is submitted that very first the suit of the plaintiff is totally false and with concocted story by suppressing the true facts. Is the plaintiff not approached this honorable court with clean hand but approached by suppressing the true actual fact. Hence the plaintiff application under order 39 rule 1 and 2 not maintainable both under law and facts. The plaintiff application for interim relief is totally vague, false and frivolous without disclosing truth and actual material fact. And the plaintiff sworn a false affidavit in support of his application, which is deserved to be dismissed to prevent the miscarriage of justice to the law-abiding innocent poor widow and her family. That the plaintiff neither in possession nor have a lawful title, and the plaintiff under collusive proceedings got RTC allegedly claiming he was purchased through auction, which is illegal, void ab initio, and the entire proceedings in which the plaintiff claimed right are also yet to be adjudicated. Until these, the plaintiff cannot claim possession based on the questioned documents. Hence, plaintiff not entitled for any relief based upon RTC. That the defendant and her family members long-standing uninterrupted possession and enjoyment since her
You are a party to that suit.
Please, madam.
Declaration and
the suit
they're
which
seeking their right by way of adverse position.
Please, I am the
Then
party.
why did you file a different suit for injunction?
Well, because they are interfering my possession. That's why, madam. They are disturbing my possession. Claiming that they have filed a suit.
When did you file the written statement in that suit?
That suit, madam. There is no date, my lords. Page 102, annexure M, my lords.
This declaration suit is of the year?
24, my lords.
You have the written statement in that,
Yes,
that. Where is that?
Page number 102, my lords, annexure M.
What did you say in that?
My lords, I am saying that subsequent to the auction purchase, I am in possession of. Well, page number 109 onwards. Para number 25 minutes.
Your sale certificate is dated, you said? 28/3/2024.
Please, my lords.
The suit is filed in the year, against whom initially the suit is filed?
My lords,
This OS number
the present
143 of 2024
Please,
is
madam.
filed by whom
filed,
and
filed
against
against
whom?
Chief Secretary. I have produced the plaint, my lords, page number 86, my lords.
Yes.
Chief Secretary and Prabhavati Nagaraj, she is the judgment debtor and the manager of the bank and recovery officer and defendant number 5 name.
You are impleted later.
Please, my lord.
You are impleted later. So by the time you entered, you are impleted in the suit, already there was a suit filed by them saying that they are in possession of the property and they perfected title by adverse possession. You being a party to that suit, again you file a separate suit for injunction.
Please. Initially, they filed a suit for permanent injunction. In that, they made an application seeking temporary injunction that came to be decreed, holding that they have no document to show that they are in possession of it. Thereafter, they filed 143/2024 against the bank and me also. And I resisted the suit, which is pending consideration. Thereafter, I filed a suit claiming permanent injunction against them. In fact, my lords, kindly see page number 169, wherein the recovery officer.
Notice or else I'll dismiss it. If you want notice, I can grant.
Kindly see page number 169, my lords.
No.
In fact, the recovery officer sent a notice to the SP requesting to give police protection, my lord, because they are disturbing my possession, my lord.
Yes, you have no position at all. By the time they filed the suit.
There is no necessity to issue separate order for possession because 38(7) itself says it is
There are
enough.
so many provisions, but that won't show that you are in possession of the
Immediate to the
property.
sale certificate, I am in
Notice,
possession.
if you
They are
want,
good.
I can hear and pass orders on the merits. Notice.
It is enough, my lords.
I'm not convinced. Yes.
Cell number 25, Umesh BN.
Defendant's writ petition, my lords. Defendant's writ petition, my lords.
What is again?
The respondent herein filed a suit for declaration, my lords. I objected for marking of unregistered gift deed, my lords, produced by the plaintiff. That came to be allowed, my lords, to be marked in the evidence, my lords.
Collateral purpose.
The court does not say it is for collateral because the very claim by the plaintiff.
Court
Please,
had directed for impounding of the document.
my lords, impounding of the
What
document,
is
my
the
lords.
suit for?
Suit for declaration, my lords. The claim of the plaintiff is
Based on
this very gift deed, my lords.
Come to the order.
It's reasoning at page 16, my lords, para 6. I've heard and after perusal of the materials available on record, it indicates that the plaintiff has filed the present suit seeking for relief of declaration to declare her as absolute owner of suit property along with perpetual by claiming the suit property did belong to her father who had executed gift deed dated 10/7/1991 as Archana Kunkma, and therefore she has acquired the ownership over the property which is being seriously disputed by other side. Here, the plaintiff is
You can come
intending.
to paragraph number 9.
Please, ma'am. So there is an order sheet which would indicate that the plaintiff has paid deficit stamp duty along with when the plaintiff was able to pay the deficit stamp duty with penalty. Again, the questioning of the deficit stamp duty would not arise for consider. I am not challenging about this portion of.
Next.
Perhaps the defendant is having every liberty to question the document as unregistered, which is the matter of trial. To what extent the document could be looked into is a matter of trial.
First of all, come to para number 1 at page number 15.
Please, my lords.
I'm not able to understand what are the two different prayers. Read that.
The defense has raised objection to mark the document styled as Archana Kunkma dated so and so by contending that it has been reduced on deficit stamp paper and it is been not registered, and thereby emphasizing that the document requires to be imported as ordered accordingly.
According to you, what I can understand from it is it should be impounded.
My lords, insofar as passing the order for the impounding, not to impound the documents, I am not objecting.
With regard to marking of the document,
please, my lord.
The court said so at paragraph number 9.
Please, my lord.
That can be decided. The court has not taken that into consideration. At the time of trial, we will consider that.
But my lords, since our claim is based on the very document, my lords, gift deed, it should not have been marked, my lords, as per section 123 of Transfer of Property Act. And
no, what that problem is, court has not given any order on that marking of the document.
Please,
court is more on the impounding of it.
Impounding of the document, my lords, because I have objected for on both reasons, my lord.
To what an extent the document could be looked into is a matter of trial. As a document has been reduced in a deficit stamp duty and is being cured with could be asserted from the outer sheet. Known to again impound the document. That is on
Please.
the impounding of the document. Then, when the materials suffice of the plaintiff having paid deficit stamp duty with penalties, court is of the view that raised by defendant is not certain it requires to be overruled. Please come. When
My
counsel
lords,
the
there is
petitioner
one more
submits,
order, my lords, which has permitted, my lords,
when counsel
where
for the petitioner submits that the defendants or the plaintiff is relying on a gift deed dated 10/7/1991 and is seeking declaration, which is an unregistered document. The plaintiff has objected on the ground that the said document, which is an unregistered document, cannot be marked in the evidence. Number two, the document has to be, even otherwise also the document has to be impounded. The court, the court has passed an order whereby the entire order dealt with the impounding of the document and his objection with regard to the non-registration of the document and marking it as a and his objection to marking of the same was not considered. See, considering the same notice.
Cell number
lords,
26.
sought for interim order.
Interim order, sir.
Please.
Cell number 26, Santosh PM.
Here for the petition. Defendant's petition, my lord. Suit for specific performance. Lord, in the plaint, my lord, the sale consideration, my lord, is mentioned.
What is the impugned order?
Annexure A is the impugned order.
Yes, let's see that.
Page number 24.
Amendment of the pleadings.
Please, ma'am.
Suit is of the year 2023. What is the suit for?
Specific performance.
Come to your amendment, that affidavit,
No, it's not my amendment application.
whoever amendment it is.
My lord, page number 31. My lord. 30 and 31. Affidavit is 31. This application, my lord, was filed.
How this amount is paid?
My lord?
How this
Cash,
am-
cash. After me I cross-examined the
Fine.
plaintiff, my lord.
In the legal notice dated 7/10/2023, the total consideration amount was correctly mentioned as rupees 3 lakhs and advance amount was correctly mentioned as rupees 2 lakhs. It's a typographical mistake.
My lord, I cross-examined
Have
the,
you given a reply notice to that,
my lord,
to the notice sent by them? But these are all typographical mistakes. How
my lord,
can you
not
take
typo.
advantage of?
My lord, it's an afterthought, my lord. My lord, I cross-examined the plaintiff, my lord.
Sale notice is not after the suit.
My
I
lord.
mean, the legal notice. Legal notice is much.
My
prior
lord,
to
even
that.
the court fee has been paid on 2 lakhs.
No, it will be paid. That is not a big issue. Yes,
My
come to the
lord,
order. Come to the order. These kind of reasons cannot be the grounds. for the
due
court to
diligence, my
interfere.
lord, there is no finding at all. On due diligence,
They
my
are
lord.
not introducing
Yeah,
any new facts.
admittedly,
It is a typographical mistake. We will consider that. Yes, please come. The agreed with the
it's after commencement of trial, my lord.
agreed with the orders passed on I number 3. It's number 576 of 2023, dated 3rd July 2026 by the additional civil judge at Chittoor. The petitioner defendant is before this court. The respondent herein has filed a suit for specific performance. Suit is of the year 2023. After the trial has commenced, the instant application is filed. That's I number 3 under Order 6, Rule 70. By way of this, they want to amend the pleadings to the extent that in the legal notice dated 7/10/2023, the total consideration amount was mentioned as 3 lakhs and advance amount was mentioned as 2 lakhs. When it comes to the plaint at page number 1, para number 2 in 6th line, the total consideration amount was wrongly mentioned as 2 lakhs instead of 3 And in eighth line, the advance amount was wrongly mentioned as rupees 1 lakh instead of rupees 2 lakhs. Hence, they wanted to amend this. That application came to be allowed by order impugned. While allowing the application, the court has observed that although the defendant contends that the amendment is intended to fill up the lacunae, such objection relates to
Afterthought, my lord.
evidentiary value, I'm reading at the order, evidentiary value of the plaintiff's case, which can be tested during trial. Mere amendment of the pleading by itself does not amount to proof of the facts pleaded. The defendant will have full opportunity to file additional written statement if necessary and to further cross-examine the plaintiff on the amended pleadings. Hence, no reparable loss would be caused. Accordingly, the court has allowed the application. When counsel appearing for the petition submits that after the amendment to the CPC, after the amendment to orders 6 to 17, once the trial commences, unless it is averred and proved that in spite of due diligence, these facts are not brought to the notice of the court, the court cannot entertain the amendment. It is submitted that only to fill up the
And one more thing. After my cross-examination, that amendment.
fill up the lacuna in the pleadings. After the defendant's cross-examination, after the PW, the plaintiff witness is cross-examined by the defendant. At that point, this application is filed. It is submitted that the post-trial amendments, without applying without proving the due diligence, the court ought not to have ordered the same. It is submitted that by way of in view of the order impugned whereby the petitioner the plaintiff is permitted to amend the pleadings would cause a lot of hardship to the plaintiff. Anything else? It is submitted that the order impugned needs to be set aside. Next, having heard the counsels on either side, there is a material on record.
One more issue also, my lord, the same has continued, and the court fee also has been.
It is submitted that the court fee already issues a frame. Court fee is also paid as per the earlier amount that is stated, that is an amount of rupees 2 lakhs. Next, having heard the counsel for the petitioner, there is a material on record. This is a suit of the year 2023 and the application is filed after 3 years. In the affidavit, as rightly submitted by the counsel of the petitioner, it is not stated how they have not, why they have not sought for this amendment at an earliest point of time. And there are lapses on the part of the plaintiff. However, this court cannot lose sight of the fact that this is not an afterthought, as already the suit is after the legal notice, before filing institution of the suit, they have already issued a legal notice. In the legal notice, they have clearly stated that it is 3 lakhs and 1 lakh. 3 lakhs and 2 lakhs. Whereas now it is mentioned as 2 lakhs and 1 lakh. And at best, this is a typographical mistake. However, that the court, while allowing applications and seeking amendment of the pleadings, have to look at the substantial interest of the parties and also what is the prejudice that would cause to the defendant. In the considered opinion of the court, this would not cause any prejudice to the defendant. As observed by the court, you will get an opportunity to file the amended written statement and the burden lies on the plaintiff to prove the same. In that view of the matter, this court finds no reasons to interfere. Dismissed.
All contentions kept up.
All the contention. This court has not expressed any opinion on the merits of the matter. All the contentions are left open to the parties. Yes.
Grateful.
7, Krishnamurthy N for petitioner. Krishnamurthy N.
Do that.
Appear for the petitioner in this case, ma'am. The defendant number 1 is before this court. Suit is for permanent injunction. After plaintiff is claiming his right over the property in respect of sale deed which was obtained in 1949.
What is the IA?
IA is filed when after the trial, when the matter stood posted for arguments, plaintiff came up with an application seeking an appointment of court commissioner.
What happened to that?
Court commissioner. And that application came to be allowed by the trial court. And the application
application is,
Then what is the suit for?
suit is for bare injunction.
Let's
Where?
see, let's read the order.
Now, application is at annexure L, please, my lord. Translated copy is a page starting from 113, please.
Para 12, let's read it. If present case is discussed, it is clear that the crux of the issue,
Please, ma'am.
impugned order,
Impugned order.
page para number 12.
Para number 12, please, my lord. So, in view of the above decision, if the present case is discussed, it is clear the crux of issue is with respect to alleged encroachment and boundaries. On the other hand, the learned counsel for the defined number one relied on so and so. This is the only reasoning, my lord. Issues are at annexure J, please, my lord.
What is the prejudice to you? No, it is not-
Prejudice.
Court is not appointing the commission for grant of issuing an injunction.
No.
At the fag end, no, you've fled, entire evidence is completed.
Please, my lord.
No, whether the court, that whatever is the commission's report, it is not binding on the court. It may help the court to decide the dispute
No,
in a
the
more amicable manner.
Point is this, my lord. The sale deed under which they claim it was purchased through auction, court auction in 1949. There is no measurement mentioned in the said sale deed. Now, under the plaint, he is claiming a measurement of 40 into 140. The sale deed which is marked before the trial court is Exhibit P4, which I have produced before this court.
That is what I'm saying, that
Please, ma'am.
contentions are all open to you.
Please, ma'am.
And you have already, the argument, the entire trial is completed.
Please, ma'am.
So now the commissioner will place a report. You
Please,
will
ma'am.
place your objections to that, what you are submitting before the court.
No.
The
Why
court will consider, so what is
Now,
wrong in it?
kindly see the IA which is filed, please, my lord. Translated copy is at annexure page 106.
No, it is not as if the commission is appointed and the court is as.
That
it
is the
going to-
reason why the commission is
No, court
appointed.
is not going to, as it is, take it into
Kindly see his
consideration.
application, please, my lord.
Yes,
106, translated copy, annexure K.
yes.
Translated copy is annexures, page 106. May I please, my lord? Application under order 26, rule 9, read with section so and so. That for the reasons stated in the affidavit submitted herewith, it is respectfully prayed that this honorable court be pleased to appoint the PWD engineer from Sakleshpur as a court commissioner to survey the properties belonging to the plaintiffs and the first defendant. This appointment is sought because despite the first defendant having no right over the scheduled property, a board has been erected on the property belonging to the plaintiffs, necessitating a survey to facilitate further. Kindly see page 108, please, my lord. Prior 108, please. Therefore, since there is a dispute as to the measurement of possession of the suit scheduled property, the honorable court prays for the appointment of PWD engineer. So this is his prayer. So court commissioner cannot be appointed to fish out the evidence. That is a known law. And also the honorable apex court and this honorable court has said, in a mere suit for bare injunction, court commissioner cannot be appointed to fish out the evidence. And also when there is a cloud over the title of the plaintiff, suit for bare injunction is not meant.
We will not go into it. This
Please,
are-
my lord. And one more document which I'll bring to the notice of this court, please, my lord.
Yes.
The municipality has, the plaintiff has given a representation.
Tell one thing, what is the prejudice cost to you? That is a simple question I'm asking from the beginning.
Please, my lord.
What will happen now?
Now, the plaintiff is claiming a title in respect of property measuring 140 into 40 square feet, my lord. 40 feet into 140. Nowhere in the sale deed which he has produced in 1949, there is no such measurement forthcoming in the sale deed. Now, by virtue of this report, if it can't be proved by the virtue of the report. This is a annexure of please, my lord.
So all the more reason you don't have to worry about it.
Please.
Because you cannot prove by the commissioner's report.
Please.
Ultimately, your evidence and their evidence is there on record.
Because this,
that the court will
this is
consider.
not to be done through a commissioner. There is a separate proceedings which the plaintiff has to do. Kindly take annexure F, which is at page 64. Translated copy is at page 66. This is the representation plaintiff gave out to the municipality to fix the boundaries and change Kata in his name. From 1949, there is no document showing that plaintiff is in possession of the property. No single piece of paper is there. Now, kindly see the report which has been given, endorsement given by the concerned municipality. Page 67, please.
Yes.
This is dated, page 66, dated 22/1/2026. Town Municipal Council, Sakleshpur. Kindly see the page 67, please, my lord. In the letter reference, the appeal is pending in the civil court, junior division, Sakleshpur in so and so. Appeal and the effect of the judgment in appeal so and so has to be considered.
Notice to the respondents.
There is.
26.
22nd is the order.
No.
That 22nd June is the order.
22nd June is the order, please, my lord.
Take out notice to the respondents.
Next year,
I'll give you a short date. Notice to the respondents. Petition
to the
permitted
council
to.
appearing for the.
Yes.
And in the
If
meanwhile.
the memo is filed.
In the meanwhile, there is.
By,
stay
the memo
placement.
is filed by 24th of August. This is March 25th.
28.
And also dispensation to defend number 2, please.
Yes, memo is filed seeking dispensation of notice to defendant number 2.
I'm grateful.
With
I appear for the petitioner, my lord. I'm the petitioner plaintiff. The suit is for the specific performance, my lord. But I have challenged the order of trial court allowing IA for continuation of delay in filing the return statement.
how much is the delay?
It's 3 years, 6 months, my lord.
What are the
And it
reasons
was,
assigned?
it was,
Reasons assigned by the court?
my lord, it was decreed, and the defendant filed the appeal. And in the appeal, it was remanded with the condition that the defendant shall file the return statement on the date of first appearance, on the 28/8/2025. Even after that also, he did not file. They did not file a return statement.
So they were supposed to appear on 28/8/2025.
Please, my lord. And they appeared, but they did not file. And the next date also they did not file. And that date, trial court had rejected the this one, not filed. And the third day they filed, but it was rejected. And after the fourth day, they filed along with the condonation of delay application, and that was condoned. That was after 3 years, 6 months, they filed it. And the reason assigned is only for the collection of the documents, nothing else.
Take out notice. Once they come, we'll impose cost. Notice to the respondents.
Stay may be granted, my lord.
Why should your suit be stayed?
It is already on the plaintiff evidence. Then it will be cross examination and then the defendant evidence.
Ultimately, once the defendants come, I'll allow that by imposing costs. Yes. Notice to the respondents. Hand summons.
Hand summons maybe. And date may be fixed, my lord.
If the hand summons are filed on 15th of September, by 15th of September, listed on 16th September.
Much obliged.
Petitioner, my lords. My lords, petitioner's application filed under section 151, my lords, seeking permission to file WS was rejected, my lords.
Permission to file?
WS, my lords, written statement.
Suit
There
is
is
of
a
which
delay.
year?
There is a suit for declaration and injunction,
Does
my
the suit
lords.
file?
My lords, actually here, my lords, summons was served on 1/3/2025.
Just ask him when is
Please,
the
my
suit
lords.
filed? Is it prior to the amendment, after the amendment?
It's prior to the amendment, my lords.
Where is that? Where do you get that?
In the plaint, it is not there, my lords.
It will be there, the signature is there.
This is the amended plaint. 2024, my lords. December 2024, it was filed, my lords.
Amendment is of June 25.
Please, my lords.
Amendment is of June 25. And how much is the delay?
16 months, my lords. She was completely bedridden, my lords. Even now, she is bedridden, my lords.
Then comes for the petitioner submits that the writ petition is filed prior to the amendment. And the written statement is filed after 18 months.
16 months, my lords.
After 16 months, it is submitted that the defendant is completely bedridden. Even till now, her condition remains to be the same. And all these aspects were not considered by the court, considering the same. We shall stay of all further proceedings and so and so. Put his hands on it.
My make on submission, my lords. Actually, my lords, defend number 1, all these things were not brought to the notice of the court, my lords. That is, she was completely bedridden. That contention was not at all taken, my lords.
Why?
My lords, defend number respondent 1 to 7, my lords.
Why you are reserving your argument for the High Court that you will not bring it to the notice of the trial court?
This was not brought.
Then if it is not brought, then why will the court consider? Why you have not filed a document? There should be a reason, isn't it?
No, my lords, actually respondent number 1.
And according to you, what is the reason for filing the EA?
My lords, here what has happened, my lords?
Not what has happened, what is stated in the IA.
IA, my lords, it is stated that they engaged a counsel and they gave instructions and all the documents were furnished, my lords. But for the reason...
It is before this court you filed any document?
I have produced all the documents, my lords.
What documents?
Medical reports.
Yes, it is submitted in her contentions. The learning council does not dispute the fact that all these aspects were not stated before the trial court. However, they have have filed those documents before this court. Yes.
Till number 30, Nagaya, co-petitioner.
But the suit is for specific performance of a contract, my lords.
IA?
But IA is filed when the matter has been posted for argument. The IA is with respect to sending the signature of the that is as stated in the agreement to the forensic laboratories.
You are the defendant or the plaintiff?
Well, I am the plaintiff. The defendant number 1 files an application to send the agreement to forensic laboratories when the matter has been posted for arguments. Well, the defendant herein agrees in his written statement that there is a forgery that has happened. That was the first place, that was the first instance where he had got an opportunity to file an application saying that this is a forged document or this is a document which is of bogus, and he had an opportunity to refer the matter for forensic. When the matter has been posted for argument at a belated stage, he files an application. And also he files a writ petition earlier for speedy disposal of the suit before the trial court.
Come to the order.
Please wait. It's at page number 20 minutes.
What happens now the stay is granted?
Minutes?
Stay of the suit should be granted now.
But I didn't understand.
Stay of the suit, you are expecting the court to stay the suit of 2010. He will ask for mandamus, you will ask for stay.
Page number 20 minutes. The present suit has been filed by the plaintiff for the relief of specific performance of contract as per the agreement of sale deed 12/3/2009. When the matter is posted for arguments on merits, the counsel for defendant number 1 filed a present application and argued that he has disputed his signature in exhibit P1, stating that he has not executed any agreement of sale as alleged by the plaintiff, and it was forged at the time.
Except your delay ground, there is no other ground in this. And it's also good for you. There will be evidence on record for the court.
But if he keeps on filing application after application, my lords, then...
So, yeah, that in this order, I will not say that let him not file any other application. Already there is a mandamus, court will dispose of. Come. The agreed with the order passed in I number 35. I number 35.
Please, my lords.
In OS number 95 of 2010 dated 23rd July 2026 by the senior civil judge and JMFC at Nelamangala. The plaintiff is before this court. Plaintiff has filed a suit for specific performance, and it is a specific case of the defendant that he has disputed his signatures on the agreement of sale. The case went on trial, and when the matter is posted for arguments. At that stage, the present application is filed to send the admitted and disputed signatures of the defendant number one in exhibit A, FP1 to the FSL for comparison of signatures. That came to be allowed by the court below. Agreed thereby, the plaintiff is before this court. The trial court, while allowing the application, has observed that in the present case, no doubt, in the present case, the plaintiff and defendants have already adduced their evidence, but there is no any hurdle to send the same to the expert. No doubt the court can come to the conclusion based on the other supporting evidence, but the very exhibit P1 is in dispute. Therefore, on considering the facts and circumstances of the case, the court come to the conclusion that the defendant has made out a sufficient ground and send the document and allowed the application. When counsel appearing for the petitioner submits the petitioner plaintiff submits that. When the right from the when it is a specific case, and file the written statement. This application ought to have been filed at an earliest point of time. It is submitted that the defendant files a writ petition seeking mandamus and also obtain an order of mandamus directing the trial court to dispose of the matter expeditiously, and on the other hand is coming up with these kind of applications, and counsel submits that, the court under section 73 of the Evidence Act is competent to look into the signatures, and it is not required to send the document for expert opinion. Next for further so and so. There is no doubt about the fact that there cannot be dispute on the fact that this application is filed at a belated stage, and at the same time, by allowing this application, no prejudice would be caused, and it would be easy for the court to decide the dispute involved. Though the court can consider the application under section 73 of the Evidence Act. In the case, the court has already passed an order send the document for expert opinion. In the considered opinion of the court at this stage, this court is not inclined to interfere with the order passed by the court. Accordingly, the writ petition is dismissed. However, it is made clear that as per the earlier order passed by this court, by a coordinate bench of this court, the suit shall be decided expeditiously.
Please,
Serial number 31, Avinash P.
My lord, appearing for petitioner in this matter, my lord. My lord, there was earlier petition dispute between the landlord and.
What is the IA?
My lord, IA for dispensation of annexure A, my lord, opinion been given by the legal advisors of BESCOM, my lord, certified copy not given, my lord. We have taken it photocopy, my lord. From
My lord, sir.
May I make submission, my lord? This is annexure A which is challenged before this honorable court. That is the internal opinion done by the legal advisors to their office, my lord. The BESCOM has not acted on that legal opinion still.
No, where is that? What is what?
My lord, page number 31, my lord. Page number 31.
31.
Annexure A, page number 31. My lord, based on a person who is a GP holder claims.
1 minute. Please come to the relief that you are seeking before the court.
Lord, sir. May I make submission, my lords?
I
In-
hear your
please,
submission provided. Let me look at the prayer,
Please,
what he is
please,
seeking.
please. Sorry.
Direction quashing the impugned legal opinion.
Please, my lord.
What is this?
My lord, this legal opinion they have given to disconnect, and as per the legal opinion, they have come to me for a disconnect. My lord, kindly see the
Can there
opinion.
be a mandamus of this nature? Asking a legal opinion to be
Not the
quashed?
mandamus, my lord. I am seeking certiorari, my lord. Kindly see, my lord.
How
Quashing
can
the
a-
impugned
how
legal.
can a writ petition of this nature maintainable? You show me some law on this, that a legal opinion will be quashed in a.
My lord, as per this opinion, they have come to my place, my lordship.
You can question the order passed by them, not the legal
Order
opinion.
they have not passed, my lord. Based on this, kindly see, my lord, what is the order they have, this legal opinion they have given. Despite the order is been.
So now every opinion given by the advocate will be questioned before the High Court, and High Court will interfere with the
My
legal
lord,
opinion.
they wanted to act on this opinion, my lord.
Certiorari, legal opinion, quashing legal opinion is writ of certiorari.
My lord, they have given opinion to the officers to disconnect the connection, my lord. Kindly see, my lord.
However, writ of certiorari lies, you please tell the court.
My lord, because they have acted or they wanted to act on this opinion, my lord. That's what, my lordship. Kindly see, my lord, though earlier they have, Bescom has given undertaking before this.
Either you
honorable.
withdraw this writ petition or I have to pass orders on the merits of it.
My lord, kindly see, my lord, one submission, my lord.
First of all, I am not convinced with the maintainability of this writ petition. Question of looking further will not arise. That how a legal opinion will be quashed, that you please tell.
My lord, they have wanted to act, they come to my
They will
place,
act.
my lord.
That you question,
That's
that
what,
action you question, how can
that's
you
what I
question
have
an-
action, my lord. Kindly, the further proceedings as per the legal I have challenged, my lord. Kindly see, my lord, I have prayer number B.
I have so many cases to hear, Mr.
My lord,
Counsel, I can't hear these kind
Prayer
of
B,
matters.
my lord, prayer B, my lord, as per that they wanted
Of
to.
all, delete prayer A, then I will say prayer B.
My lord, kindly.
Lords,
No.
submission, my lords. I'm filing power for.
I'll delete, my lord.
6, my lords.
File it in the
Please.
registry.
My lord, I am permitted to delete that, my lordship, that prayer, my lord.
Look at it, you better withdraw this and file a fresh writ petition. With
Good.
these kind of allegations, will not entertain the writ petition.
My lord, only prayer by A, I'll delete it, my lordship.
What will happen to all your pleadings which are in support of your prayer number 1?
My lord, same thing, my lord, all these pleadings is, my lord, kindly see, my lord, I have not pleaded anything with respect to anything, my lord. I have pleaded only with respect to my title, my lord, what they have stated in the legal opinion, my lord.
Whatever you want to do. If it is not, if I can't entertain, I will pass orders. The petitioner shall submit that. He will amend the
My lord,
prayer.
my lord.
Yes. I will not pass an interim order. Yes, this matter, when you will file?
My lord, no? I'll
They have
withdraw,
not
my
taken
lord.
any administrative action on the legal opinion, my lord. I checked with the officials.
You don't have to submit on that first. If you take action, you will question the legal opinion here.
We cannot, my lord. That one.
Yes. When do you want?
My lord, and day after tomorrow, my lord.
Yes, day after tomorrow.
Great.
Cell number 32, HP Raju, for petitioner. NG Sridhar.
No representation. This matter in the month of October.
Cell number 33, RA Devanand.
Appealing for respondent.
May I please, your lordship?
Where is the impugned order?
The suit
Before
is,
submitting, state of application, will actually directed them to produce the documents along with the IA, which translated they did not produce it. Last date of, along with the IA, they have filed application to produce the document.
Where is the order sheet?
no, he undertook to produce certain document, not me. That's how time was taken about 3 weeks before. Now he cannot now pass on the buck to me.
At the time of argument, since the documents were there, I have tried to the knowledge of some.
Keep the mic proper for him.
Sorry.
Yes.
But on the last act of hearing, my lord, I have brought to the knowledge of the Assam court with regard to non-filing of documents along with the IA, which is under challenge, my lord. Well, lordship directed them to produce the documents, my lord.
My lord, whatever documents I have enclosed along with my writ papers would suffice and convince the court.
No, you are supposed to.
No, I never undertook.
Not undertook. Whatever the material before the trial court, that should be here.
No, it is there, it is there.
That was his case on the last
And
occasion that it was not there.
In fact,
What are the documents filed? You please pass on. You are also not ready on that. Yes, you argue.
my lord, suit is one for injunction.
Yes.
The respondent is the plaintiff in the trial court.
Yes.
The petitioner is the defendant.
Yes.
My lord, this suit is in relation to a dispute called a site number 10 of a definite area.
Before we'll go to that, what is the impugned order now?
Impugned order is an IA was filed
Yes.
under order 26 rule 9 to send exhibit P 20 and 21, which are the general power of attorney and the affidavit executed by the respondent's vendor's mother in the year 1982. In the year 83, that property was sold it to my mother, that is a petitioner's mother.
Is she alive?
Huh?
Is she alive?
Who?
Who has executed the GPA?
No, she is not alive.
Then how they will compare the signatures?
There are specimen signatures are there. And in 83, my mother, that is petitioner's mother, purchases the property. In 2006, she transferred that property by way of sale to me, that is to her son. That is the respondent here, petitioner herein. In the year 2013, this respondent purchases the very same property. So therefore, earlier, my lord, this matter was decreed in favor of the respondent herein. Matter was carried before this court in RFA. Kindly be at page number 96.
No, please come to the impugned order first, then we'll go to the other pleadings.
Impugned order is page 129, the reasoning starts. 129, paragraph 29. 28.
Where this order has started from 112.
Or 112.
And where is the reasoning part?
That is, earlier paragraphs are deducing the facts of the pleadings and the IAS, and the earlier making a reference about the RFA before this court.
Come to 28.
Paragraph 28. Initially, the suit was decreed by filing RFA before the Honorable High Court. Defendant has got the suit remanded, and to the judgment is not set aside on merit. The matter is remanded to this court for trial once again, and even time bound was fixed by the Honorable High Court of Karnataka. However, defendant filing one application other and same is delaying the matter. Moreover, defendant is not questioning the exhibit P20 and 21 or exhibit P9, the sale deed of the plaintiff, only has sought for relief of possession without declaratory relief in respect of in respect to the legality and validity of the document. Application filed at the fag end of the case, referring the document to fingerprint expert for comparing with other documents which are not related to the present dispute, which are objected by one of the sons of Ganga Lakshmama, is not sustained. This is the reason.
What is the suit for?
Suit for bare injunction. It was decreed in favor of the respondent. Matter was carried in first appeal before this court. This court said when there is a thick title dispute between the plaintiff and the defendant, the plaintiff was judgment was set aside. Matter was remanded to the trial court for plaintiff to give a chance for her to mold the relief of declaration as well to the present existing relief of permanent injunction. She did not do that. On the other hand, an evidence was let in after the remand, and thereafter an opportunity was given to me as well as a defendant, and I led evidence by examining one of her sons of Ganga Lakshmama, Lakkama, whose mother is the respondent's mother, who got the GPA exhibit P20 and 21 in the year 1982 from Ganga Lakshmama, which is an undisputed owner. Now, exhibit P20 and 2021 are fake documents created by the sons of Lakkama and came forward to execute a sale deed in her favor.
So, in his suit, the defendant wants to prove by sending all this that those documents are fake.
Fake. And I contend that it is a suit for permanent injunction, but I denied the title to its score. You kindly see paragraph 98 of the judgment of the appellate court. I think that will make the things very clear. 98, the operative portion. I am inviting my lords to operative portion. 98.
How is it relevant to prove those documents in a suit for injunction?
She contends that she is in. That is the reason by law can. After reading of the order, operative portion of the RFA, I think my lord would rather be convinced about it. Order 98, in page 98. The petition, instead of appeal, they say petition is allowed. The impugned order and decree dated 13/11/24 passed in so and so court is hereby set aside. Did my lords got it?
Yes.
Prayer 3, matter is remanded to the trial court for reconsideration afresh in accordance with law. Then para 4, the Roman 4, parties are directed to appear before the trial court on 7/4. Para Roman 5, the trial court is directed to frame an additional issue in relation to the title and proceed accordance with law by permitting both the parties in addition adducing additional evidence. Para Roman 6 and para Roman 7, that's a direction. This is important. Para Roman 8. Further, as directed by this court in the interim order 7/3/2025, any construction being put up by the respondent on the suit scheduled property or the counterclaim suit scheduled property shall be subject to the final outcome of the suit, and the respondent shall not claim any equity as regard to the construction or possession of the suit scheduled property or counterclaim of the scheduled property. It is further directed, in event respondent is unsuccessful in the suit, after remand, respondent shall restore status quo ante, shall hand over the possession of the property to the appellant, in relation to which the trial court that passes appropriate order. Now, this appellate court directed the plaintiff to amend her suit to add a relief of declaration under section 34 to the existing relief of permanent injunction. It is no more a permanent injunction suit before the trial court after the remand. And the trial court also framed an additional issue. It was required to be, or rather she did not amend the proceed further.
Now, she is only entitled for injunction.
Please.
And in the light of the settled law, as she has not sought, mere suit, bare suit for injunction is not maintainable, court will decide it.
That observation, my lords may kindly dispose.
I will
of it.
not. Why will I go into all that?
No, otherwise, what will happen is this.
Otherwise,
what will happen is this. Now, this appellate court directed her to amend the suit to include the relief of declaration. An issue is framed, and she has led evidence. What I am required to drive home a point for my lord's consideration is Exhibit P20 and 21 are the two documents which are unregistered document, which the respondent's vendor's mother had obtained it from Ganga Lakshmama way back in the year 1982. In the following year, 83, I obtained a registered sale deed. Thereafter, it was sold it to me in the year 2006 to me as our son. And in the year 2013, on the strength of those two documents, Exhibit P20 and 21, she proceeds to, she obtains a registered sale deed and files the suit for injunction.
Please come.
With that observation,
I will not make any observation on that. Agreed with the order.
Otherwise, what will happen is the judgment of the appellate court, after analyzing the evidence and the pleadings of both the parties, came to a conclusion that
High Court under 227 will not do all that.
No,
I'm
what
only
I'm trying to
concerned
say
with
is-
what is order impugned, whether it is right or not. That's it. Agreed with the orders passed on.
Then the
I number-
finding may be little disturbed, maybe disturbed, because the case of the finding of the trial court is, I have not proved exhibit, I have not questioned exhibit P20 and 21. That is what the trial judge say. That is wrong. That was expected of him to do that. On the other hand, she shifts the burden upon me rather to say, I did not prove so as to justify the validity of my application for.
Yes, I have looked at it. I'll pass order.
Please.
Order on 9 number. So and so. Then, voice number 5354 2013 dated 5th June 2026. The defendant is before this court. Respondent herein filed a suit for injunction. Once it is decreed and the matter was remanded. While remanding the matter, the court has directed the plaintiff to has given liberty to the plaintiff to seek the relief of declaration. Thereafter, the matter went on, and in the course of the trial, the present application is filed under Order 26/10A, that is Section 151 CPC, to appoint fingerprint. This is filed by defendant, fingerprint expert to conduct scientific investigation into the fingerprint of Srimati Ganga Lakshmi, which is appearing.
Not Ganga Lakshmi, Lakama.
Looking at from the order, I'm saying
No, that may be wrong. Not Ganga Lakshmi, Lakama.
that you should have sought for a clarification of the order.
Vendor, mother of the vendor. Exhibit
Sought
P.
for clarification of the signature appearing on Exhibit P20. Where is your IA?
Please, madam.
Where is your IA?
Page number 101.
101.
Page number 101.
Annex IA number 9 or 10. 101. Annexure E.
You write Ganga Lakshmi and you want this court to write something else.
No. Ganga Lakshmi, what said?
Fingerprint of Srimati Ganga Lakshmamma. That's what you sought. That's what the court has recorded. Yes, write that. fingerprint of Srimati Ganga Lakshmamma appearing on exhibit P20 at 3 different places, and also fingerprint of Srimati Ganga Lakshmamma appearing on exhibit P21 at 2 different places, with a comparison of fingerprint of the original agreement of sale executed by Srimati Ganga Lakshmamma and her children in favor of Srimati R. Rajendran dated 10/11/1981. It is a case that the thumb impression is all created and manipulated by 2 sons of Ganga Lakshmamma. The court, by order impugned, had dismissed the application. While dismissing the application, the court has observed that at the time of remand, the court has directed the trial court to dispose of the matter in a time-bound manner. However, defendant is filing one application or the other, and the same is delaying the matter. Moreover, defendant is not at all questioned or challenged exhibit P20 and P21 or exhibit P9 sale deed of the plaintiff, and only has sought for the relief of possession without seeking any declaration or relief with respect to the legality and validity of the document. The application filed at the fag end of the same, referring the documents to fingerprint expert for comparing with other documents which are not related to the present suit and which are objected by one of the son of Srimati Ganga Lakshmamma, is not sustainable. Hence, in the facts and circumstances of the case, the application filed on behalf of the defendant seeking for referring exhibit P20 and 21 for comparison of thumb impression forthcoming in sale agreement and partition deed dated 19/11/1981 and 16/4/1984 is not at all sustainable and is accordingly dismissed. Accordingly, the application is dismissed. You have filed a counterclaim for recovery in this.
Absolutely, there is no counterclaim of recovery of possession.
Yes, sought for counterclaim of injunction, madam. Counterclaim of injunction.
Injunction, not a possession.
What is
your
statement? My suit is for injunction suit.
Then
He
what
is also sought for counterclaim of injunction.
Oh, you sought for
Possession.
counterclaim you sought.
But my lords would get it on page 44.
You have sought for or not counterclaim?
Absolutely not.
You have no counterclaim.
I have sought only for a degree of perpetual injunction. That's all against her.
Is it a counterclaim or not?
There is, but
Yes.
not the possession as
That is what I wanted to know. Yes.
That indicates in the
Having the land counsel appearing for the petitioner submits that. The court observes that. The court observes that the petitioner has not questioned the petitioner defendant has not questioned challenged exhibit P20 and P21 or exhibit P9 sale deed of the plaintiff as per the remand order passed by the appellate court. In fact, the petitioner has to or the plaintiff has to seek for the declaration of title. Even after remand, the plaintiff has not sought for such a relief. The said finding of the court is contrary to law and also contrary to facts. And court also observes about recovery of possession. That is also not correct. It is submitted that unless and until these documents are sent for the expert opinion, the dispute between the parties cannot be adjudicated in an effective manner. And it is the submission that while dismissing the application, court has failed to give cogent results. Next para. When counsel appearing for the respondent, plaintiff submits that the defendant has sought for a counterclaim of injunction, and the court has rightly observed that the defendant is coming up with one application or the other, and because of that, the suit proceedings are delayed. It is submitted that there are no reasons to interfere with the well-considered order, and the court and the repetition is liable to be dismissed. Next part. Having heard the counsels on either side, there is a material non-record. The suit of the respondent herein is one for a bare injunction. The defendant has sought for a counterclaim, also sought for injunction. The suit is decreed. Thereafter, the judgment and decree was set aside and the matter was remanded. In the order, there was a liberty to the plaintiff to seek declaration. Admittedly, no declaration is sought by the plaintiff. Now, in a suit for bare injunction, where the reliefs of both the parties are seeking injunction, according to the the defendant, the exhibit P20 and 2021, the left hand thumb impression of the mother, that is Ganga Lakshmamma, is according to you, it is a
Compared, Ganga Lakshmana, those documents were concocted and the basis
or a
of those
concocted documents.
Her
And
sons have executed two of
her
her
sons have executed the
sale
sale deeds in favor of the defendants. Hence, that has to be sent for the expert opinion. The trial court observed that those documents are not questioned by the petitioner, that is the defendant herein, who has already filed a counterclaim. However, he has not sought for any declaration that those documents are forged documents and those documents are not binding on him. In those circumstances, court has given a finding that now it will not serve any useful purpose, and when those documents, the validity or otherwise of the documents is not going to be decided by the court, sending them for expert opinion is inconsequential, and accordingly dismiss the application. In the considered opinion of the court had rightly considered and dismissed the application, and there are no grounds to interfere.
Look, can I seek indulgence, small concession in the matter? The exhibit P20 and 21, considering the changing of the defendant hearing can also be looked into. P21, 20 and 21 should
You
not
already
be
filed
brushed
so
aside.
you already filed so many applications. You filed one more.
I should not be brushed aside while considering, because it is.
I didn't
processed for
say
final
anything.
act.
I am only on this point. Because those documents are not question of going into the whether they are valid, legal, and does not arise. Yes, 35.
Should be looked into by the trial court while deciding the title of the plaintiff to say that
I will
she
not
is in
tell
lawful
anything.
possession of the property.
This court has not expressed anything on the merits of the matter. The trial court shall proceed in accordance with law.
Cell number
Yes.
34, Nishant GK for petitioner.
Well, I appear for the petitioner. Suit for specific performance. Suit for specific performance. This is a defendant's writ petition. Impugned order is at page number 24, my lords. I had filed an application order 26 rule 10A. I had sought for 2 of the signatures to be sent to a forensic lab because my specific content.
This is a suit for?
Specific performance. I am for the vendor, my lords, landlord vendor.
You are the defendant.
Yes, my lords. And I had filed an application order 26 rule 10A seeking for 2 signatures to be sent to the government forensic lab. Now that comes to be rejected, my lords. And
Why do you want it to be sent?
my lords, what happened is, my lords, the document on which that I've sought for it to be sent to the forensic lab is an addendum that is produced by the plaintiff at a later stage in the suit. Now, through this addendum, they claim that there's certain consideration that has been paid in fulfilling the condition.
You are denying them.
Yes, I am denying the existence of the document itself. There are 2 signatures, my father's and my signature, that has been appended to the.
When those documents are placed on record?
My lord, after the evidence, my lords, it was not placed along with the suit papers.
Then you filed your objections to that.
I filed my objections. It came to be allowed. Now that came to be allowed, and that has been marked also as Exhibit P18. Now I am disputing the signatures that is found at P.
So what is the present stage?
My lords, now it has been posted for judgment. It was for arguments, my lords, and now it has been posted for judgment. My lords, what has happened is, my lords,
Right of the division bench judgment. We cannot, once the matter is posted for judgment, nothing can be done.
My lord, this writ petition was filed when the matter was posted for
It's not a
argument.
ground, you know.
My lords, may I just take your lordship's
No,
indulgence,
we'll
my
not
lords?
go because we will not decide anything now because the matter is posted for judgment.
My lord,
If you tell the court, show the law that even after matter is posted for judgment, still this court can go into the legality or otherwise of any impugned order passed on I. If you say, I will look into, if you place a document,
My lord,
judgment.
before that, my lords, may I just take my lords to two documents, my lords. Just one document.
It is of no use when
No.
I am not interfering in the light of that fact. If I look at entire documents and I feel that you have a case, then also I can't pass an order.
My lord, in fact, when the writ petition was filed, my lords, at the stage of arguments.
But that's not-
And
that
that
is
is,
not,
that was brought to the notice of the court, the trial court. However, they proceeded to post the matter for
They are
judgment,
bound
my
to
lords.
because there is no stay.
My lords, that I understand, my lords. However, my lords, now the entire claim of the plaintiff is that,
Better luck in the, before the
I'm
appellate
sorry, my
court.
lords.
Before the appellate court.
My lords, there's about,
Did any order against you?
my lords, there's about 4 crores consideration that,
But we can't do, that's what I'm saying. I am saying that the division bench or judgment is this, or the Supreme Court judgment is this. You say, you place some other judgment.
my lord, it's for the stage of filing written arguments. I'm sorry. It is for the stage of filing written arguments and not judgment. It has not been posted for judgment. It's,
Show me the case status.
yes, my lords. The last order will not be in this writ petition because it was filed before, my lords, but I will just, my
Tomorrow,
lords will
I'll
find
take up this matter tomorrow. Get the online case
tomorrow,
status.
my lords. Very well.
This is matter tomorrow in the first list. Yes.
Cell number 35. Vivek S. for petitioner.
Yes.
Petitioner is the owner of the land bearing survey number 60, my lords, measuring 4 acres 38 kundas.
But what is the IA? All those arguments are not required. Straight away to the point.
This is KBTCL matter, my lords.
Huh?
Lands of petitioner has been.
Yes, come to the prayer. If it is a writ petition, KEB matter, come to the prayer.
Page
And
number
then
16, my
you
lords.
can state the facts.
Prayer is at page number 16, my lords.
Quashing the public announcement dated issued by the assistant engineer insofar as relate to affect the petitioner's land. So why should these proceedings be stayed? That you can tell the court.
Because they have erected the transmission towers over the petitioner's land, my lords, without following due process nor.
We'll ask them to follow due process.
They have not notified the petitioner prior to drawing of transmission lines, and in fact.
We'll ask them to follow all the procedure in vogue and also the notification issued by the central
That has been
government.
followed by the deputy commissioner. Compensation has been fixed. In this survey number, 100% are the owners. There is no identity of the each person. The land, total land, 1 acre 162 acres. That we are utilizing the only corridor area. Towers already erected, no one has objected. Now, once they are entitled for compensation, on account of number of owners, we will deposit the compensation before the district judge under 16(4) of the for disbursement of the who are entitled interested person.
He has to go before the court, deputy commissioner.
District magistrate, the deputy commissioner, not that district judge, jurisdictional district judge under section 16(4) for
You
disbursement
already-
of the compensation.
Yes.
We will deposit there.
Approach. The writ petition is filed, sing the following prayer. Land counsel the petitioner submits that the respondents are laying the lands in the petitioners have laid the land and laid the towers in the petitioner's land. It is submitted that no notice is given to them, no procedure known to law is followed, no compensation is paid to the petitioners. Leonard, Mr. Devraj, appearing on behalf of Mr. H.V. Devraj, appearing on behalf of the respondents, all respondents, appearing on behalf of the respondent submits that in fact they
Respondents
have
1 to 4, the fifth respondent is the Tahsildar. I am not.
1 to 4. Fifth respondent, HCGB takes notice. It is submitted that in fact they have followed the entire procedure. The total extent of land is 100 acres and odd.
100 acre and 62 acres.
162 acres. 162 acres.
About 100 persons are in position.
100 persons are in possession of the property. As they are not able to, then you will, when you buy, you have, whoever is in possession, you would have given notice to them.
But the notice, the sketch has been prepared. In the sketch, that ADLR has prepared a sketch showing all the persons are the owners. That we can't disperse in that.
Say for 165 acres, all 100 people are owners.
Owners. But because of that, in the entire land, they have not, owners have not get it ported the land that their extent is concerned.
It is submitted that the as per the revenue records, the entire 162 acres, 100 persons were shown to be the owners of the property in those circumstances. As they could not disperse the amount, they have deposited the entire compensation before the district judge under 16(4).
16(4) of the Telegraph Act.
Under section 16(4) of the Telegraphic Act, as a petitioner is seeking compensation, and he cannot question he cannot have any grievance for laying off the towers and the electric lines, that is in the interest of the larger public. The only remedy is to seek the compensation. Next para, having other counsels on either side, was a material non-recorded. And it is the submission of the accounts for the respondent that already they have laid the towers in the respective lands at measuring an extent of 1 acre 65.
162 acres are in the entire survey number.
In 165 acres. In survey number?
In survey number 60.
60. The petitioner is claiming
4 acres.
4 acres 38 guntas. And no podi is conducted.
No podi has conducted.
No podi is conducted, and entire 100 people are shown as the owners of this 165 acres of land. When they've admittedly already lines are laid and the amount is deposited.
No, not a deposit. No, we'll deposit under 16(4). Not a
will you do
deposit. No, we will deposit within 4 weeks. Not the deposit.
When was it laid?
Let the towers have erected. Line has not yet been completed.
Does it amount to
not
complying with the law?
Towers have been erected. Line has not yet been drawn. Once line drawn, that will take a measurements, we will deposit the entire compensation.
Your circulars, your rules, what
The
do
circular,
you say?
the sketch has been prepared. Sketch the annex.
When it has to be paid.
Annex.
It is not at your convenience, isn't it?
Let that circular says that at the tower completed we need to pay one payment, and the stringing that we have to pay another payment. Now towers have been completed.
When?
That now completed. Therefore, produce the photographs.
Today afternoon?
Not afternoon. With before filing the petition, it has been completed.
Then you should have paid by this time.
That we'll deposit before the court. We are taking steps on.
Not will steps.
That within 4 weeks, record my submission.
Why 4 weeks? When the law says that you should do it immediately, why 4 weeks?
That if owner is there, that immediately we'll pay it.
No, you deposit it before the civil court.
We'll deposit. We'll deposit within 10 days. We'll deposit. May kindly record that.
I will say that then it is not for you have not followed the procedure.
The procedure has followed for preparing sketch and notifying the owners. All this has been.
No, it doesn't say.
And compensation also has been fixed.
Procedure will not stop till you only till acquiring the land, installing the towers. The procedure further follows.
That will
till the
only
compensation
we have to not that because of the assertion in this.
No,
we
within
will
1 week,
deposit before this.
Within 1 week you should do it.
Yes, I'll do.
What did you write? And it is submitted that within a short time, they will deposit the amount.
Subject to one.
This court is not able to appreciate the said submission on behalf of the respondent. As per the procedure, they have to pay the compensation at 2 levels.
2 levels.
One is once the towers are completed, and the second is
The stringings are completed.
once stringing is completed. Now at this stage, now they have completed the towers are already installed. Within 1 week from today, the respondent shall deposit the compensation before the competent court as per section 16(4) of the Telegraphic Act. The petitioner is at liberty to approach the civil court accordingly disposed of.
Much.
Yes.
Serial number 36, SV Bhatt.
Petitioner in this.
Yes.
The petitioner is the defendant in the suit for partition, has filed an application seeking permission of the court to file the additional letter statement in view of the application for amendment filed by the defendant plaintiff at a later stage.
No, when was the amendment allowed?
The amendment was allowed quite some time back. It was allowed on.
Because
yes,
he files because you get a right to file additional written statement that you will not exercise after so many years.
The application came to be allowed on 21st of January 2016. However, additional written statement stage was not put, court was not, has not posted the case for additional written statement at all. At no point of time, I have been given the opportunity to file the additional
Court
written
need not
statement.
give you any
The amendment
opportunity. It follows. Court need not give you any opportunity. It follows. Once the amended plaint is filed, you will get a right to file your additional written statement. That's why you.
That was, no stage was fixed for that purpose. The Supreme Court says,
Come to the
Supreme
order,
Court
I
says,
understood it. Come to the order.
page number 175, para 8 is the last, that is the only paragraph wherein reasonings are given. The after amendment of the plaintiff has led her evidence and defendants have cross-examined PW1 based on her pleadings. Thereafter, defendant number 2 has led in evidence as DW1 based on the available pleadings. Advocate for the plaintiff fully cross-examined DW1, and when the matter was
Oh,
posted
where
for
is that
final,
order? Present order. Where is it? Page number.
page number 175, my lord. It starts at page number 170, and the 169. The relevant portion is at page number 175, para 8.
After amendment of the plaintiff led her evidence and defendants have cross-examined PW1 based on her pleadings. Thereafter, defendant number 2 led his evidence, DW1 based on the available pleadings.
Right. I do concede that. I have stated in my affidavit also. But however, I said that I have not been given an opportunity to file the written statement, additional written
I'm not able
statement,
to understand
because that
what is that
amendment,
opportunity.
Affects me. It is to incorporate the property belonging to me as a joint family property.
No, court should say that court should plead you to file the additional written statement. When you are able to understand that you have to go, you can examine the defendant, you can do so many things. And
Milord, Supreme Court, 2009 Supreme Court, this is what Supreme Court says, Milord.
Take that.
Give a copy, sir. Give me a copy.
Yes, what it says?
Para 19 is the relevant paragraph, Milord.
Arising under the Rent Control Act. Yes.
Para 18, sir. Sorry, it is para 18.
Yes.
It is also well settled that while allowing the additional counter statement or refusing to accept the same, the court should only see that if such additional counter statement is accepted, the real controversy between the parties could not be decided. As noted earlier, by filing an additional counter statement in the present case, in our view, would not cause injustice or prejudice to the respondent, but would only help the court to decide the real controversy between the parties. In our view, High Court was therefore not justified in rejecting the application for permission to file the additional counter statement.
Not after 10 years. Not after 10 years. 16 amendment of plaint. 2026 he wants to file additional after evidence is almost completed.
Right, Milord. I do concede, but the 10 even
time who will answer to the time? 10 years. Who will
ultimately it is
not
my right.
ultimately who
My
will
lord,
compensate that?
My right in respect of property. It's a suit for partition. Suit for partition. I claim that this property, they have included this property when the evidence was begun. They have included this property. That I am claiming that it is my independent property. That is all what is the contention. That is the prejudice that would be caused to me. Even 2002 Supreme Court also.
My lord, it all depends on facts of the case. The law is there. It has to be applied to the facts.
My lords, I'm filing a synopsis and an order sheet.
Copy?
Yes.
Yes.
May I just draw your lordship attention to the date also, Millard.
Which date?
Relevant date. I have produced the order sheet, entire order sheet
Here it
itself.
is. Look at it. She has also placed a synopsis. Dates from this we'll see. Yes.
My lord, this suit was filed on 27/5/2013. Then returns statement was filed. And then on 6/4/2015, IA number 6 came to be filed by the plaintiff to amend the plaint with respect to item number 4 as scheduled property. Then opportunity was given to the defendant. He never filed objections to the application. And cost was also imposed, my lords, in the petition copy, page number 63 to 64 can be perused. Kindly turn to page 63 and 64 of the petition. 6/4 was the date IA number 6 was filed, and multiple opportunity was given. On 2/9/15, cost was also imposed. He never filed objection to that. Page 65 on 21/6/15.
I'm looking at your synopsis.
Yes, I've written there also, my lords. Then on 21/2016, the court made this observation while allowing order number 6. It says on payment of cost of ₹500, yet the defendants failed to file their objection and failed to pay cost. And on 2/9/2015, objection to IA number 6 was taken as not filed. And subsequently, amended plaint was filed on 9/2/2016. And it has been 10 years now, they have not filed the written statement to that. And then again, on 7/6/2024, they file an IA number 17 for amendment of the written statement, which has been rejected. That is on the documents which I have provided just now, my lords.
Yes.
Page 17. Page 17. The IA came to be IA number 17 under order 6 rule 17 was filed by the defendant on 7/6/24. And on page 18, again, IA number 18.
No, order impugned is dated.
Order impugned is
This was
dated
the previous, on the same averments, he has filed order number
24th
17.
June 2026.
Order number 17 was for amendment of written statement, which was rejected. They have not challenged that. And again, now subsequently on 6/4/2026, again, on the same averments, they filed IA number 20.
Sorry, that is wrong. It is not on the same ground.
And it is 10 years.
Not on the same ground.
And the matter
That
is posted
application
for
came to be
final
rejected.
argument.
I concede that application came to be rejected. That was an application filed by all the defendants jointly together to amend the plaint. In fact, that was legally not permitted for the reason that there was a jointly written statement was filed. Now, Millard, in respect of one property, it is only the first defendant who is who claims to be the owner independently. He files this application independently, saying that earlier he was not given an opportunity to file the.
That I want you to elaborate on that.
Right,
What is not giving an opportunity?
The order sheet in subsequently there are several other applications.
According to you, giving an opportunity means after the date of their amending their plaint, every
Yes.
day the court will be posting the matter for filing.
And not even once, not even once. It has taken only the return, the additional return.
You have filed so many applications after that.
No, I have filed only 3 applications, all applications there.
What are you doing?
They have filed 2 applications for amendment
What are you
subsequently.
doing from 2015 to 2026? You are not attending the court, you are not going to the.
I was
proceedings.
attending the court. I am not saying
I'm
that.
not
I am
coming.
not saying that.
I'm not coming.
I am only seeking this opportunity for the reason that otherwise my right gets affected.
You should
Yeah,
be-
I am not in a position, otherwise without the pleading, without the
You are being
pleading.
vigilant about your pleadings. Your other judgment also, please give. I'll record the judgment also.
One more, 2002 Supreme
Yes.
Court.
Give it.
Very,
Para number, please write the para number.
yes, madam.
Yes, please come.
Para 19 is the relevant paragraph, wherein
The agreed with her.
wherein the Supreme Court clearly says that when one of the party has been permitted to amend his pleading, an opportunity has to be given to the opposite party to amend his pleading. The opposite party shall have to make an application in Order 6 Rule 17 CPC, which of course would ordinarily and liberally be allowed. Such amendments are known as consequential amendments. The phrase consequential amendment finds mention in the decision of this court in Bikaram Singh versus so and so. The expression is judicially recognized. While granting a leave to amend pleading by way of consequential amendment, a court shall see that the plea sought to be introduced is by way of answer to the plea previously permitted to be incorporated by way of amendment by the opposite party. A new plea cannot be permitted. It is not a new plea. It is only amendment, additional statement by way of reply to the amendment that they have carried out. It is only that.
My lords, in the stage is final arguments, and the plaintiff has finished her arguments, and it's posted
Agreed
for
with the
arguments
order.
of the defendant.
Agreed with the order on I number 20, notice number 374 of 2013, dated 24 June 2026, by the City Civil and Session Judge CH2 at Bangalore. The petitioner, defendant is before this court. The respondent herein has filed the suit seeking partition and separate portion of the 1/7 share in schedule item number 1 to 3 of the plain properties against the petitioner and respondent 2 to 6, as well as their father. Defendants 1 to 6 jointly have filed their written statement on 3/12/2025. An
May I
application.
just start this juncture? May be permitted to withdraw the petition so that I can, in the first appeal, I can challenge this.
The memo is filed, you file a memo.
Please, ma'am.
The memo is filed seeking to withdraw the writ petition with the liberty to raise all the grounds before the appropriate forum. Yes, accordingly dismissed as withdrawn. Yes.
Cell number 37,
Pleading for petitioner.
Savita D.
In this case,
petitioner.
my lord, suit has been filed by the petitioner for grant of decree of permanent injunction, restraining the respondents from putting up further construction.
Come to your prayer. What is the prayer you are seeking?
My prayer is to, my lord, work order has been issued for 10 flats, my lord. Disam Court, my lord, directed the parties.
Come to your prayer. Let me look at your prayer. What
Please,
is
ma'am.
it? Where is Mr. Kartikeya?
Page number 26, my lord.
Work order, technical
Issue
sanction.
writ of cessation quashing the
Issued by the BESCOM authority in the way respond as its sanctions for the place.
issued by the BESCOM
Why should
authority.
we interfere with this?
My lord, your lordship kind to, before that, my lord, I have approached the civil court for grant of decree of permanent injunction. We have constructed 10 flats, my lord. Since there is a dispute, my lord, they not to dispossess the petitioner from the property, my lord. At the first instance, interim order was granted. Thereafter, it is vacated, my lord. Thereafter, I have approached the Disam Court by filing MFA, my lord. Disam Court, my lord, directed the parties to maintain status quo with regard to the property, my lord. Thereafter, my lord, the interim order was modified. Well, also can you turn to page number 47, my lord.
Page number?
47. Interim order dated 25/9/25. I am concerned with the B schedule property. I heard the learned counsel from both the sides.
Who are the respondents in the suit?
Well, the respondents, my lord, 1 to 7. You will also can turn to.
Who are the respondents in this MFA 5209 of 2020?
Same persons, my lord, same persons.
I have to look at the call.
But I have not produced the
Without the
MFA
copy, I
copy. my lord.
understand.
But I have not
MFA
produced the
order.
MFA copy, my lord. I should have, my lord. Now, my lord, out of 10 flats, my lord, 5 flats gone to the share of original developer, my lord. 5 flats to the petitioner, my lord. Now we want to install electricity connection to both the parties A and B scheduled properties, my lord. My lord, I have submitted representation to the KEB authorities. You can install you can give electricity connection only to 5 flats, not to the B scheduled property, which is in possession and enjoyment of the property. And the Disam Court has granted interim order. Despite submitting the representation, my lord, they are proceeding with the.
Where is your representation?
My lord, representation at Annex E, it is in Kannada, my lord. Should have. Sorry. Because I hurriedly, my lord. This is what I have stated.
Then you read and you understand.
I will file the translated copy.
Now what is to be done?
Well, it's a
Anyone is
day.
not there, you file the translated copy tomorrow.
Tomorrow.
And tell him, tomorrow in the first list.
Please.
Cell number 30.
Yes, take it.
230 mention matters. Cell number 59. Cell number 59.
For the petitioner, my lord. But the matter arises from execution proceedings and the petition is by the JDA.
There's some extension of
My lord,
interim
interim
order.
order had been granted on 7/1/2026, but on the last date of hearing, the previous counsel on record had filed a memo of retirement without enclosing any particulars. For that reason, it was not extended, my lords.
The writ petition itself is not maintained, my lord, because, my lord, in the execution case, the FDP order is there, kindly see, my lord.
They filed a memo of retirement on so and so, without filing any relevant document. The writ petition is of the or granted on, so the petitioner counsel shall file the counsel for the respondent shall file a. You have filed the retirement memo.
No, my lords. The previous counsel on record, Advocate Chandrakant K. Patil was the previous advocate. I have received the NOC and I filed the.
The relevant particulars. However, in the facts and circumstances, this court is not inclined to extend the interim order granted by the coordinate bench of this court, because you take an interim order, you don't take, when you have taken the no objection, you have to engage a counsel.
It was, my lord, the retirement memo, when the retirement memo was filed, it was not intimated to the to the parties. That was the limited ground.
Yes, why the writ petition is not maintainable?
Madam, because, my lord, the FDP proceeding itself, the position is handed over and the RTC is entered in the name of the respondent 113. All the respondents, this is a partition suit. And the separate position has been given, my lord. Kindly see, my lord.
No, first of all, take this court to the impugned order.
Yes, my lord.
Where is the impugned order?
Impugned order, my lord.
52.
Next year.
Page 52, my lords.
We have filed the application for police protection, my lord, for executing the final decree order, my lord.
1 minute.
Passed in FDP number in the execution case. Execution case filed with the respondent 1.
There is no 52 here.
My lords. Page 52, my lords. Annexure F, my lords.
Your last page is 50.
That is a statement of objections filed by the respondent, my lords.
I'm looking at this. This is your writ petition. What is the page number?
Lords, in my copy, it's page number 52, my lords. Annexure F.
50.
This is order sheet of the trial court, my lord.
Wait, please wait. 50?
52, my lords.
The Taluka surveyor is hereby directed to assess the court ameen to find out the properties. So for demarcation of the property, that order is questioned by you.
My lord, there is a composite order passed for survey, for demarcation of the boundaries of the property and for delivery immediately. Our limited contention is, let the survey be conducted, let the survey report be filed.
The other order.
My lords, there is only one order, my lords. So one composite order ranging from page 53 to 58, my lords.
The court ameen is hereby directed to take assistance of the Taluka surveyor and police to execute the delivery warrant. The jurisdiction police is hereby directed to provide necessary police help. When was the position delivered to you?
Position delivered in respect of, kindly see page number 56. 56. In the writ petition, my lord. The DHR Srimati Sheila has filed the OS number so and so for the partition separate position of the her 1/4 share in the suit schedule properties, and after passing this preliminary decree, she has filed the FDP number so and so, and in the said FDP final decree drawn on 14/9/2022. Thereafter, DHR filed a present petition to take possession of the property which allotted to her share. The court, while drawing the final decree allotted to the parties properties to the parties on the basis of the report submitted by the ADLR. Already ADLR submitted a report, my lord. On the basis of the report, the ADLR prepared the sketch and submitted the report to the court. And after hearing the both the side, court has accepted the report. Now the JDR number 2, contesting that the properties have not been surveyed, demarcation is drawn on
No boundary was fixed without fixing the
We'll hear
boundary.
it some other day.
Yes, my lord.
We'll hear it. The interim order.
No, my lord, kindly say, my lord. Because, my lord, I have filed my objection, my lord.
Not
And
that.
also, if,
You're not answering to
no,
my
no, no,
question.
RTC kindly within the RTC, my lord, is already our name. Partition taken place. While we are going there, my lord, they have protested me. That's why, my lord, I filed the police protection.
I'll only understand how I can understand. When I'm asking a question, you don't answer to it and you argue in your own fashion.
Already, my lord, already partition has taken place and ADL has submitted a report demarking the, my lord, I have produced the,
I asked you a date. When was the position given to you? You don't tell that.
yes,
You
yes,
start reading
kindly see, my
something.
lord, my document kindly see, my lord. Page number.
I don't see the document. You tell the date.
No, no, date I will tell the date, my lord. 14/3/2025, my lord. The MR entry has made on 14/3/2025. As per Annexure R10.
This order is dated.
This order dated, my lord, recently, that is in the month of
12/12/2025, my lord.
12/12.
Then why
It
did
is
you
in
say
25.
that he cannot question this order?
No, 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 I am not caution, my lord. Can you see the RTC also? RTC is also made in favor of me. That is the year 2023 itself. The FDP order passed in the 2023. In the FDP itself is given all the properties and the share has been delivered.
On the last occasion, when counsel the petitioner submits as the earlier counsel has stated that he has no instructions to appear, the court has directed them to, court has directed him to file all the documents. However, the stay was not extended. Now he has moved the court seeking extension of the earlier interim order. Land counsel for the respondent submits that the writ petition is not maintainable and the position is delivered to him. Interim order is granted by the court on a coordinate bench of this court.
7/1/2026.
7/1/2026.
2026.
That order dated 7/1/2026 is extended.
Kindly see, my lord, there is the position are delivered on 23/25.
If you are, I will record it according to the respondent, the position is already delivered. However, due to paucity of time, this court is not able to hear the matter. The interim order earlier granted is extended.
Till the next date of hearing, date may be given, my lord.
State of hearing. List the matter on 3rd of September.
Please.
Yes, next.
Cell number 82.
A is disposed.
Cell number 82.
For the petitioners, my lord. The suit is of the year 2023, my lords. I filed a suit for permanent injunction. Plaintiff is the petitioner herein, my lords. Plaintiff is the tenant, my lords, under a 2018 lease deed. Defendant number 1 is the landlord, my lords. Defendant number 2 is the bank. My lords, apparently there has been a mortgage between.
This is IA.
My lords, it's at Annexure A, my lords, page number 20.
Yes.
So what has happened is, my lords, during the.
I don't have to know what is happening. I just want to know what is the order.
My lords, Annexure A, my lords, page 20, my lords.
Page number?
20, my lords.
Yes. And where is the order? Where is the
My
reason?
lord, there's no order as specific, my lords. When the matter was pending for hearing on 39/194 and 39/4, my lords, the learned trial court judge vacates my interim order, my lords, which was granted in 2023. He says you're taking time.
Come to that. Where
Please,
is
my
that
lords.
vacation of the order?
Page number 20, my lords, Annexure A.
Yes.
My lord, Sri so-and-so advocate filed NOC wakalat for the plaintiff and praised time for hearing on IA number 1 and filed memo stating that he has not received the copies, but it is opposed by advocate for the defendant. He's also filed an application under 151 of CPC to extend the interim order, but the plaintiff has obtained the interim order on 2023, but all along not ready for consideration of IA number 1 on merits.
We'll ask the court to decide the IA.
Please, my lord.
We'll ask the court to decide it on merits of it.
Let it be considered, but they are not ready for argument.
My lords,
Because
please.
they have taken the sufficient time. Anyhow, our application is
Please
pending for.
listen. I'm saying I'll ask the court. I'll fix a date.
Please.
On that day they have
Yes,
to.
yes.
And this injunction that is granted, let it be enforced till such time. I'll fix a date. If they don't argue, it will be automatically vacated.
That's the
One,
wrong
one
submission.
more submission.
Yes.
Till disposal of the interim application, I will not take any actions against the That is a petition before this. That is
What is the interim order granted?
not to interfere over the shoe property. That is that is a secured property. We have adopted all due process of law under the Surface Act. That is a bank. That is a bank. We have taken all the steps against that is a landlord as well as the tenant, various provisions of the Surface Act.
My lords, one more point, one last submission. On page 51, my lords, I have partially addressed arguments, my lords. On the next stage, my lords, I have filed this and I have taken time because I did not have a copy, my lords. It is not that I have not addressed the arguments at all.
Okay.
Please, ma'am.
Next hearing, you address
Please,
your
ma'am.
arguments
Please.
or else they will proceed with the matter.
Please,
That's what
ma'am.
I'll
I will
say.
address my arguments.
Please.
Agreed with the order dated 4/8/2026, whereby the court has refused to extend the interim order and also given liberty to the defendant number 2 to proceed with the property as per the provisions of Surface Act. The petition is before this court. When counsel for the petitioner submits that there is no intention on the part of the petitioner not to proceed with the matter. In fact, he has concluded the argument partially, but the court, without considering all these facts, and if the interim injunction is vacated, the property is put to auction, it would cause a lot of hardship to the petitioner. Plaintiff was not appreciated with the court, and the court has failed to extend the interim order. Then counsel appearing for the respondent. Which respondent you are here?
Yes, I am a second defendant. That is a second defendant respondent.
Then counsel appearing for defendant number 2 and the respondent number 2 herein submits that as a petitioner has obtained an interim injunction on 6/7/2023, until now he has as he has failed to proceed with the arguments on IA number. What is this?
IA number 1 bar 2023.
My lords, and IA number 1 of
2024. As there was no other alternative, court has refused to extend the interim order. It is submitted that the petitioner, having obtained an order in Section 2023, cannot continue to have the benefit of the order without arguing the matter. Next para. Having heard the counsels on either side, that's the material on default. The suit is for bare injunction.
That is a bare injunction.
Suit for bare injunction against the bank.
Against the bank as well as the landlord. Let them take action against your landlord for recovery of that amount.
That you please tell the
That is
court.
their option.
Against the landlord and the bank. The court has granted an injunction restraining the respondents from interfering with his possession. That order was granted on 6/7/2023. According to the order dated 4/8/20, the order dated 4/8/2026 disposes that petitioner, having obtained the order on 6/7/2023, is not advancing the arguments, but all along not ready for consideration of IA number 1 on merits. Hence, the temporary injunction cannot be extended. If a party who obtains an order of injunction and forever seeks extension of it, and if it does not proceed with the argument, the court will not have any other option but to pass an order of this order where they refuse to extend the interim. This court, having heard both the counsels and balancing the interest of the parties, passing the when this court has expressed the record that you will not conduct.
We will not take any action till disposal of the application for vacating of the application.
Balancing the interest, when this court has expressed that the court will fix a date for hearing of the IA, then counsel for the petition has insisted for a order to be restored, then counsel for the respondent submits that till the IA is decided, they will not proceed with the auction.
Please.
Considering the submission both.
No action to take physical position respect of secured property.
Position of the property. Considering the submission of both the counsel, this court is passing following order. The writ petition is disposed of, directing the plaintiff to proceed with the arguments in IA number 1 of 2024. When is it coming?
That is September 30th.
September 30th to conclude the arguments. One day will be sufficient.
So
one day will be sufficient.
Yes.
To conclude the arguments on September so and so. September so and so. If the petitioner fails to till such time, till the arguments are concluded, defendant shall not take any further steps. Number 3, on the day If the plaintiff fails to submit his, proceed with the arguments, the defendants are at liberty to proceed further.
Please.
I'm grateful, my lords.
Which one? No, this hand summons also. This also, I think we can, 1 minute. Waited. On this maintainability issues you call, so that they'll get time for, or call from 61,
Serial number
no, 58.
Serial number 58. Serial number orders matter. Serial number 58. Giri Kumar SV.
Yes, adjourned by a week.
Serial number 59. 59 not ordered. Serial number 60.
That also after a week. 61,
Serial number 61.
office object, what is that called? This also?
Along with submission.
Oh no, this let it be there in the list.
Yes.
Best mark.
Serial number 62. Postal Shara unclaimed for order.
Notice to R1, returned with the postal share unclaimed, amount to deemed service of notice. In all these matters, if stay is there, extend. Yes.
Serial number 63. Memo of and summons filed. Please for time, my lord.
This matter, after 2 weeks, look at it, interim order is there, extend.
Serial number 64.
64, my lord, applied for the petitioner. My lord, the matter is rendered infractious, my lord. May be dismissed as.
Then comes for the petitioner, submits that the writ petition has become infractious, accordingly dismissed as infractious. Case
Serial number
65,
Grateful.
Memo of calculation.
let it be there tomorrow in the list.
Yes. Serial number 66. Serial number 66. Sagar BP.
Let it be there. 67.
67. Affidavit of order.
To R1, returned with a postal share unclaimed, amount to deemed service of notice.
Lord, I'm pressing for interim order, my lord. Even they refuse to.
Not hearing for any interim order.
Please, my lord. They refuse to.
Let it come tomorrow.
They refuse to. My lord, for a moment, date may be fixed, my lord.
Tomorrow I'm saying.
Please, my lord, please.
68.
I don't understand this anxiety of the advocate when the court is saying tomorrow to fix the date. I'll fix the date on October.
Time is over now. That's why I thought court is going to.
Yes, 68.
Please, my lord.
My lords, appearing for the respondent. My lords, I
You
request
appear for whom?
for the respondent.
All the respondents.
No, my lord. This.
How many respondents are
Only
there?
one. my lord, for round
Only
one.
one?
Yes.
Write your name. So and so submits that he has instructions to file wakalat on behalf of so and so. Look at it. If interim order is there, extend. List it in the month of September someday. Yes,
Number 69.
Bring the petitioner, Mother.
What is this office objection?
That office objection regarding that the respondent number 4 here in Mother. Respondent number 6, Mother. He has not made as a party in education petition, Mother. That is the office objection, Mother. That respondent number 1 has filed the education petition, Mother. He has not made as a party in the respondent number 6, Mother. The Lordship may kindly see cast title that respondent number 6, Venkata Reddy, who is the dependent number 6 in original suit, Mother. And your Lordship may kindly see come to Annexure C.
The abhorrent, what is the objection?
Page 41, Mother.
Operation execution of the proceedings on the file of the so and so. The abhorrent petition papers were notified for rectification following. Parties to be clarified with the execution petition and ranking before the. Where is the impugned order?
The impugned order the mandamus, Mother. I sought for mandamus, Mother. I have filed the regular appeal, Mother, before the appellate court, Mother.
Which year is the appeal?
That respondent number 1 has filed the original suit, Mother.
Which year is the appeal?
Appeal is 2025, my lord.
Why should the court direct 2025 appeal to be disposed of?
I am not seeking any speedy disposal, my lord. I filed the applications before in the RA, my lord. Your lordship may kindly say annexure F, my lord.
What are those IAs?
That IA is one is for the order 1 rule 10, my lord.
IA numbers, no numbers.
IA number 2 as page 61, your lordship may kindly say page 61, my lord.
If you tell me the numbers, it will be sufficient.
It is not taken on record, my lord. Those IAs are not taken on record. Page 61, my lord. Annexure F, my lord. Order 1 rule 10, my lord. Initially, I filed this regular appeal against the 2 persons, my lord, two respondent, my lord. Subsequently, I filed the application for impleading, my lord.
Where is the other application?
Other application annexure G, my lord.
No,
Order 41 rule 5.
These are 2 applications. What is third application?
The third application is that annexure E, page 54, my lord. That I filed the inquiry affidavit. So far as the RA is delay in filing the application for 5, my lord. On that basis, I filed the affidavit for chief examination on the inquiry, section 5 of the Limitation Act, IA, my lord. That chief examination affidavit also not issued by the appellate court, my lord. On the reason that the appellant is advanced age, my lord. 96 years, I can't issue that she is the advanced age. They have not issued the chief examination affidavit, my lord.
The following prayers. It is submitted that in an RA of 2025, he has filed these applications, which are annexure E, F, and G. One is on E, F, and G, considering the fact that they are pending from 2021. This court is passed the following order. So it says that
I sought for that execution of the stay of the execution till disposal of the appeal, my lord.
That I will not grant. The trial court shall consider the same within a period of 4 weeks from the date of receipt of the copy of the order. Yes.
Number 70.
Please.
70 report.
What is this report? Give that. Where is that order? Show me the order. The petition is filed seeking the following prayer on 27/7/2026. Considering the submission of the land counts for the petitioner, if the suit is of year 2007 and the petition is aged about 88 years, seeking a mandamus, this court has directed to call for a report from the concerned court as to how much time is required to dispose of the suit. The learned judge has placed a report stating that for disposing of the suit, 9 months period is required. Considering the same, this court is passing the following order. Writ petition disposed of, directing the court to dispose of the suit itself within a period of 9 months. Yes.
71. K. Vijay Kumar.
Petitioner, my lord.
What are these office objections?
And office objection, a common orders passed, a single writ petition filed.
What are those?
My lord, rule says only writ petition, but one writ petition maintainable.
No, that is the old story. Present is you have to file 2 writ petitions, and it all depends upon what are the nature of application.
My submission, my lord, is in that regard. A common order passed in all same
I'm
applications.
saying what are those 2 orders?
Lord, for each writ petition, my lord, for each order.
No.
Yes.
What are those 2 IAs and what are those 2 orders? That I want to know.
One, my lord, page number 20, my lord. 18 rule 17, recall and reopen application.
Recall and reopen.
Reopen.
Yes, office objection with regard to the office objections are overruled. List is matter tomorrow. Tomorrow or day after?
Tomorrow, my lord.
Tomorrow.
Grateful.
Yes.
Number 72.
Office objections will be complied within a week, or else the writ petition shall stand dismissed
Cell number
without further
70.
reference to the court. Look at it, interim order is the extent.
Cell number 73.
For petition,
Sultan Cyril.
Yes.
there's two of the petitions. One is regarding the number of parties, but right now the petition is filed only related to the impleading order. That is why not in the merits of the suit. That's why the other parties are not relevant to this case, Your Honor.
But you have to show them. You have to array them as parties. Then you say that they are not necessary parties. But it is not that cost title also you will not show them. Office objections or sustained
180.
petition shall comply with the office objections. And immediately after complaints of the office objections, list this matter. Yes, 74 in the first list. 74.
Appearing for petitioners council, my lord. Appearing for petitioners council, my lord. More than one IA, my lord.
What are those IAs?
Kindly have it tomorrow, my lord. It's held up in.
Let me look at.
He's here.
Yes, what are those two IAs?
Three IAs were filed, Manoj. One is for production of additional documents. The other two were to recall and reopen the stage of defendant evidence.
Yes, office objection is overruled. List this matter tapped tomorrow.
13th is for argument, final arguments, Manoj.
When is it coming?
13th of this month.
13th is day after tomorrow. 13th we'll have.
Manoj, it was
13th on 13th first case. Yes.
Grateful, Manoj.
So that one matter less in the list tomorrow is some happiness to the court.
Cell number
Grateful,
75. Dhananjay GN. 75.
Yes.
2 weeks. 3 IAs there, ma'am. I'll file
No, it's not about 75 is regarding maintainability of writ petition in view of section 115.
Yes, my lord, 3 IAs on single order has been passed. So order 6 rule 17, one application is order passed. So I'll press that application only. I will
Then
comply the
counsel for
order.
the petitioner submits that he is only questioning the IA that's filed under order 6 rule 17. Accordingly, the petitioner petitioner shall carry out necessary amendments and serve the copy on the caveator. Serve?
Not yet.
Serve on the caveator. List this matter on Thursday. Once the necessary amendments are carried out. Yes.
Cell number 76. Swaroop S.
Common order on recall reopen.
Yes, office objection with regard to the maintainability. Yes.
Thursday, month.
Thursday? Yes, Thursday.
I appear for R1. I will file my wakalat.
So INSO submits that he has instructions to file
Caveat
wakalat.
is not filed, but I'll.
There is a direction from division bench to dispose of the matter within 1 year. That period is already expired.
Yes, 77. All these matters right in the first list. All whatever adjourned. Yes, 77.
Number 77.
Except which are given in the month of September and October. All August matters first list. Yes, 77.
77. Sushma HR.
Yes, in the list tomorrow. Yes, 78.
78. Bal Gangadhar GS.
Yes, let it be in the list.
79. Abraham Joseph.
Yes, 80.
80. Parani.
Yes, in the list.
Objection, my lord. IA number 19 and 20, both are, my lord, only producing the documents and the GPA holder permission to continue proceed with the case by the GPA holder, my lord. IA number 19, additional documents. 20 is the GPA holder to continue the proceedings, my lord.
Yes.
Since it's a
Office
97 years
objection with
old.
regard to maintainability is overruled. This also on the.
The tomorrow case is there for the final, they'll reserve it for the judgment again, my lord.
When was the impugned order passed?
Impugned order passed, my lord, on 9/7/2026, my lord.
And tomorrow it should be taken up to yesterday you have filed, today it has come. Tomorrow I have to hear. Wednesday. Yes,
Cell number 81.
Short list.
first list.
Much of
Cell number 81. A. Madhusudan Rao.
Yes, tomorrow. Yes, 82.
82 disposed. 83. Cell number 83.
Notice. Notice.
For petitioner, my lord.
85.
85.
Let it be there. 86 notice.
86 rupees.
Notice.
Execution file.
No. 66 days I will not grant. Yes. Notice in all this, whenever I say notice, hand summons. Also, in addition, hand summons.
Great.
Yes. 87.
87.
They filed an application for early hearing.
What is this 2026 matter early hearing? Yes, let it be in the list.
Great.
Next preliminary hearing. Okay, maintainability one.
No, no. Yes.
One submission, Malad.
Yes.
On Thursday, this honorable court has directed serial number 94, mandamus direction. Mandamus direction 94, my lord.
Serial number 96, my lord.
1 minute. What is that, 94?
94, mandamus direction. On Thursday, it was directed to the government advocate to get the instruction.
Where is the government advocate? Huh? List this matter day after tomorrow. At
On top of the list are preliminary. Press matter, my lord.
My lord, serial number 96, my lord. Serial number
raising
96.
94 at that
My lord,
day after tomorrow.
My lord,
serial number 86, my lord. 86, my lord.
Your lordship, cause list 2, your lordship, cause list 2.
Serial number 66.
Ma'am, what about the cause list 2?
ನಾಳೆಗೆ serial number 2 ಇದಪ್ಪ second list.
Ma'am, what about the cause list 2? What about
ಸುಮ್ಮನೆ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಹಾಕ್ಸ್ಕೊಂತಾರೆ ಇದು ಆಗಲ್ಲ ಸುಮ್ಮನೆ ಕಾಯ್ಬೇಕಿಲ್ಲ
ಎರಡನೇ ಸರಿ ನಮ್ಮ
Ma'am, what about cause list 2 date?
ಸಂಜೆ ಆಫೀಸಲ್ಲೇ ಅವ್ರ ಕೆಲಸ ಆಗ್ತವೆ.
What is to be held court on?
2 weeks. ಅದೇ ಮೇಡಮ್ ಹೇಳಿದ್ರು ಎಂಟ್ರಿ ಮಾಡಿ ಎಕ್ಸ್ಟೆಂಡ್ ಅಂತ ನಾವು ಎಂಟ್ರಿ ಮಾಡೋದು.
No, I'm not mentioning. I'm not.
ಚೇಂಜ್ ಆಗಿದೆ
ಅಲ್ಲಿ 3 ಜನ ಒಬ್ಬರು ಆಗಿದ್ರು.
ಒಂದ್ ನಿಮಿಷ ಸರ್, ಒಂದ್ ನಿಮಿಷ. ಲಿಸ್ಟ್ ನಂಬರ್ 1 ಅಲ್ಲಿ ಈಗ ಎಲ್ಲಿಗೆ ಸ್ಟಾಪ್ ಆಗಿದೆ ಅಲ್ಲಿಂದ ನೆಕ್ಸ್ಟ್ ಆಲ್ ಮ್ಯಾಟರ್ಸ್ ರಿಪೀಟೆಡ್ ಎಕ್ಸೆಪ್ಟ್ ವೇರ್ ಎವರ್ ಎಂಟ್ರಿ ಮಾಡರ್ಸ್ ಆರ್ ದೇರ್. ಎಂಟ್ರಿ ಮಾಡರ್ ಯಾವ ಯಾವ್ದ್ರಲ್ಲಿದೆ ಹೇಳಿ. ನಾಳೆ 57 ಅಲ್ಲ, ಒಂದ್ ನಿಮಿಷ 57 ಅಲ್ಲಿ ಐವೋ ಇದೆ, ಇದು ಅರ್ಜೆಂಟ್ ಆಗುತ್ತೆ ಹಂಗಾರೆ. ಎಂಟ್ರಿ ಮಾಡರ್ ಆಗಿ ಡೇಟ್ ಹೋಗುತ್ತೆ ಸರ್, ಅದು ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ ಸರ್. ಇನ್ನು ಯಾವ್ದ್ರಲ್ಲಿ ಐವೋ ಇದೆ ಹೇಳಿ ಲಿಸ್ಟ್ ನಂಬರ್ 1 ಅಲ್ಲಿ.
62
90 ಅದೇ 96 ಅಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡರ್ ಇದೆಯಾ ಇವ್ರೆ? ಎಂಟ್ರಿ ಮಾಡರ್ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಿ ಡೇಟ್ ಹೋಗುತ್ತೆ ಇವ್ರೆ, ಅದು ಸೆಪ್ಟೆಂಬರ್ ಅಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ. ಶಾರ್ಟ್ ಡೇಟ್ ಎಲ್ಲ ಇಲ್ಲ ಇವ್ರೆ, ಶಾರ್ಟ್ ಡೇಟ್ ಇಲ್ಲ.
ಮೇಡಮ್
ಅದೇ ಮೇಡಮ್ಗೆ ಟೈಮ್ ಇಲ್ಲ ತಗೊಳಕ್ಕಾಗಿಲ್ಲ ಅದನ್ನೇ ಇವಾಗ ಹೇಳಿದ್ದು wherever interim orders are there
Madam, ಕೇಳಿಸ್ತಾ ಇದೆಯಾ?
you extend and give it in the month of September first week ಅಲ್ಲಿ ಕೊಡಿ ಒಂದ್ ನಿಮಿಷ
ಮೇಡಮ್ ಲಿಸ್ಟ್ 179 ಏನಾಯ್ತು ಮೇಡಮ್?
ನಿಮ್ಗೆ ಅಲ್ಲಲ್ಲ ನೆಕ್ಸ್ಟ್ ನಿಮ್ಗೆ ಹೇಳೋದೆಲ್ಲ ಪ್ರತಿ ದಿನನೂ 55 60 ಮ್ಯಾಟರ್ ಇದೆ. ಆಗಸ್ಟ್ ಅಲ್ಲಿ ಒಂದು ಡೇಟ್ ಇಲ್ಲ. ಆಯ್ತು 19 ತಗೊಳ್ಳಿ.
ಮೇಡಮ್
87 ಇಂಟ್ರಿ ಮಾಡಿದೆಯಾ ಸರ್? ಮೊದಲು ಅದಿದೆ ಅದು ನಾಳೆ ರಿಪೀಟ್ 87
ಮೇಡಮ್ 62 ಮೇಡಮ್
ಸರ್ ನೀವು ಅದನ್ನ ಕೇಳಬೇಕು ಇಂದ ಪ್ರಿಲಿಮಿನರಿ ಹಿಯರಿಂಗ್ ಅಲ್ಲಿ ಬರಬೇಕು ಅದು ಅಂತ ನೀವು ಕೇಳಲ್ಲ ಸುಮ್ಮನೆ ಅದು ನಾಳೆ
ಸೀರಿಯಲ್ ನಂಬರ್
ಯಾವ್ದಾದ್ರು ಸೀರಿಯಲ್ ಲಿಸ್ಟ್ ನಂಬರ್ 2 ಸೀರಿಯಲ್ ಏನ್ ಸರ್ ಹೇಳಿ ಸರ್ ನಿಮ್ದು ಹೇಳಿ 34 ನಾಳೆ ರಿಪೀಟ್ ಆಗುತ್ತೆ ಲಿಸ್ಟ್ ನಂಬರ್ 2 ದೆಲ್ಲನಾ ಲಿಸ್ಟ್ ನಂಬರ್ 2 ನಲ್ಲಿ ನಾಳೆ ಬೇಕಾಗಿರೋದು ಯಾವುದು ನಮಗೆ ನಾಳೆ ಮೆಮೋ ಫಾರ್ ರಿಟೈರ್ಮೆಂಟ್ ಅಲ್ಲ ಇದ್ರಲ್ಲಿ ಐಒ ಇದೆಯಾ ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರಾ ಅಲ್ಲ ಸರ್ ಇದ್ರಲ್ಲಿ ನೋಟಿಸ್ ಆರ್ಡರ್ ಆಗಿದೆ ಆಲ್ರೆಡಿ ಈ ತರದೆಲ್ಲ ಅರ್ಜೆಂಟ್ ಆಗುತ್ತೆ ಸರ್ ಏನಂದ್ರೆ ಫ್ರೆಶ್ ಒಂದ್ ನಿಮಿಷ 13/8 ಗೆ ಡೇಟ್ ಇದೆಯಾ ಇಲ್ಲ ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಎಲ್ಲ ರಿಪೀಟ್ ಆಗುತ್ತೆ ಇಂಟ್ರಿ ಮಾಡಿರೋದು ಮಾತ್ರ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ ಇವ್ರೆ ಇಂಟ್ರಿ ಮಾಡ್ರ್ ಎಲ್ಲಿದೆ ಅದು ಮಾತ್ರ ಡೇಟ್ ಹೋಗುತ್ತೆ ಮುಂದಕ್ಕೆ ಬೇರೆ ರಿಪೀಟ್ ಆಗುತ್ತೆ ಯಾವ್ದು ಡೇಟೇ ಇಲ್ಲ ಇವ್ರೆ 13th ಗೆ ಸರ್ ಆಲ್ರೆಡಿ ಅದಲ್ಲೆಲ್ಲ ನೋಡಿ 55 ಮ್ಯಾಟ್ರ್ ಇದೆ ನಿಮ್ಗೆ 13th ಗೆ 17th ಹಾಕೊಳ್ಳಿ 87 ನಾಳೆಗಿದೆ ಅಲ್ಲಲ್ಲ ಮೇಡಮ್ ಲೆಟ್ ಇಟ್ ಬಿ ದೇರ್ ಇನ್ ದ ಲಿಸ್ಟ್ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಹೋಗಿದ್ದಾರೆ ಅದನ್ನ 87 ನ ಲೆಟ್ ಇಟ್ ಬಿ ದೇರ್ ಇನ್ ದ ಲಿಸ್ಟ್ ಅಂತ ಅಲ್ಲೇ ಇದೆ ಮೇಡಮ್ ಹೇಳೋದ್ಮೇಲೆ ನಾವು ಇದೊಂದು ಕಾಲ್ ಔಟ್ ಆಗೋದನ್ನ ಹೇಳ್ಬಿಟ್ಟಿದ್ದಾರೆ ಅದು ಲೆಟ್ ಇಟ್ ಬಿ ದೇರ್ ಇನ್ ದ ಲಿಸ್ಟ್ ಬೆಳಗ್ಗೆ ಮೆನ್ಷನ್ ಮಾಡಿದ್ದೆ ಅಲ್ವಾ ಸರ್
ಮೇಡಮ್ ದಿನ ಬರೋದು ಕಾಯೋದು ಹೋಗೋದು
ರಿಪೀಟ್ ಆಗುತ್ತೆ ಸರ್ 44 ಸರ್ ನಾವು ಏನು ಮಾಡೋಕ್ಕಾಗಲ್ಲ ಅದು ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಮೇಲೆ ಡಿಪೆಂಡ್ ಅದು ನಾಳೆ ಇವತ್ತು ಡೇಟ್ ಅವರ್ ಸಿಟಿಂಗ್ ಇದು ಡೇಟ್ ಆಗಿದ್ರಿಂದ ಲೀಕ್ ಆಗಿಲ್ಲ ಅದಕ್ಕೆ ನಾಳೆ ರಿಪೀಟ್ ಆಗುತ್ತೆ ಯಾಕೆ ಹಿಂಗೆ ಒಂದು ನಿಮಿಷ ನಾನು ಒಂದು ಕಡೆಯಿಂದ ಕೇಳ್ಕೊಂಡು ಬರ್ತೀನಿ ನೀವೇ ಇದೆಲ್ಲ ನಾನೆಲ್ಲ ಫೈನಲೈಸ್ ಮಾಡೋದಿಲ್ಲ ಡೇಟ್ ಆದ್ಮೇಲೆ ಮತ್ತೆ ಲಿಸ್ಟ್ ಅಲ್ಲೋಗುತ್ತೆ ಲಿಸ್ಟ್ ನಂಬರ್ 2 ನಲ್ಲಿ ನಾನು ಡೇಟ್ಸ್ ಅಸೈನ್ ಮಾಡಕ್ ಆಗೋದಿಲ್ಲ ಅನ್ಲೆಸ್ ಯು ಹ್ಯಾವ್ ಮೆನ್ಷನ್ಡ್ ಇನ್ ದ ಮಾರ್ನಿಂಗ್ ಹಾಗಾದ್ರೆ ನಿಮ್ಗೆ ನಾಳೆ ರಿಪೀಟ್ ಮಾಡಿದ್ದೀನಿ ಸರ್ ನಂಬರ್ 8 ಏನ್ ಹೇಳಿ ಇನ್ಫೆಕ್ಷನ್ಸ್ ಆಗುತ್ತೆ ನಿಮಗೆ ಹೌದು ಕರೆಕ್ಟ್ ಇವ್ರೆ ಅದು ಸಬ್ಮಿಷನ್ ಮಾಡಿ ಇನ್ಫೆಕ್ಷನ್ಸ್ ಅಂದ್ರೆ ಡೇಟ್ ಹೇಗೆ ಡಿಸ್ಪೋಸ್ ಆಗುತ್ತೆ ನೀವು ಪ್ರತಿದಿನ ಲಿಸ್ಟ್ ನಾವು ನಾಳೆ ಲಾಸ್ಟ್ ನಾಳೆ ಸಬ್ಮಿಷನ್ ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ ಅದು ಸೆಪ್ಟೆಂಬರ್ ಸರ್ ಅದು ಆಸ್ ಇಟ್ ಈಸ್ ಅದು ಲಿಸ್ಟ್ 1 ಲಿಸ್ಟ್ 2 ಎಲ್ಲ ಅನ್ಲೆಸ್ ದೇರ್ ಇಸ್ ಅ ಸ್ಪೆಸಿಫಿಕ್ ಡೈರೆಕ್ಷನ್ ಫ್ರಮ್ ದ ಇದು ನಾವು ಅದನ್ನ ಆಲ್ಟರ್ ಮಾಡೋದಿಲ್ಲ ಲಿಸ್ಟ್ 2 ನಲ್ಲಿ ಇರುತ್ತೆ ನಾಳೆ ಬೆಳಗ್ಗೆ ಮೆನ್ಷನ್ ಮಾಡಿ ಲಿಸ್ಟ್ 1 ನಲ್ಲಿ ಎಲ್ಲ ರಿಪೀಟ್ ಆಗುತ್ತೆ ಏನಂತ ಹೇಳಿದ್ರೆ 62 ಆರ್ಡರ್ ಆಯ್ತಲ್ಲ ಅದು 62 ಆರ್ಡರ್ ಆಗೋಯ್ತು ಇದೆ 62 ಆರ್ಡರ್ ಆಯ್ತು ಆರ್ಡರ್ ಆಗಿ ಎಂಟ್ರಿ ಮಾಡಿ ಎಕ್ಸ್ಟೆಂಡ್ ಆಯ್ತು ನೀವು ಸರ್ವಿಸ್
ಮೇಡಮ್ ಮತ್ತೆ
ನಿಮ್ಮ ಕೇಸ್ ಕಟ್ಟಾಗ ನಿಮ್ಮ ಮತ್ತೆ ವಾಟ್ ಅದು
ನಮ್ ಕತೆ ಹೇಳಿ ಈಗ
ಮೇಡಮ್
ಹೋಗ್ರಪ್ಪ ಅಯ್ಯೋ ಯಾಕೆ ಹೇಳ್ತಾರ ಪಾಪ ಈ ಅಮ್ಮ ಮಾತಾಡ್ಬೇಡಿ ಅಂತ ಹೇಳದ್ ಬೇರೆ. ಮೇಡಮ್ 90 ನಾಳೆ ಕೊಡ್ತೀರಾ ತಾಯಿ? ನಿಮ್ದೆಷ್ಟು
ಮ್ಯಾಮ್ ಲಿಸ್ಟ್ 2 ಮ್ಯಾಮ್.
ಕೊಡ್ತೀರಾ? ವೆಕೆಟ್ ಹಾಕಿ ಸಾಧ್ಯನೇ ಇಲ್ವಲ್ಲ. ಅವ್ರು ಹೇಳಿದ್ರಲ್ಲ ಬೇರೆ ಎಂಟ್ರಿ ಮಾಡಿದ್ರೆ ಕಂಟಿನ್ಯೂ. ನಿಮ್ಗೆ ನಾಡಿದ್ ಬೇಕಲ್ವಾ? ಜನಾರ್ದನ್ ನಾಳೆ ಇರಲ್ಲ ಅಂದ್ರು.
ನೀವೇ ಪೆಟಿಷನರ್ಗೆನಾ ವಿದ್ಯಾಸಾಗರ್? ಅಲ್ಲ ಡೇಟ್ ಹೋಗುತ್ತೆ ಅಷ್ಟೇ. ನೀವೇ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡಿ ರಿಕ್ವೆಸ್ಟ್ ಅಂತ ಬರುತ್ತೆ.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಮೇಡಮ್
ಹೇಳಿದ್ರು ಜನಾರ್ದನ್.
ಸಬ್ಮಿಟ್ ಮಾಡಿ ನಿಮ್ ಪೆಟಿಷನರ್ ಅಡ್ವೊಕೇಟ್ ನಾಳೆ ಏನಾದ್ರು ಸಬ್ಮಿಟ್ ಮಾಡ್ತು ಅಂತಂದ್ರೆ ನೀವು ಸಬ್ಮಿಷನ್ ಮಾಡಿರೋದೇ ಅಡ್ವಾನ್ಸ್ ಆಗುತ್ತೆ. ನಾವ್ ಹೇಳಿದೀವಿ ಇದೆಲ್ಲ. ನೀವು ಸುಮ್ಮನೆ ಅನ್ನೆಸೆಸರಿ ಸಬ್ಮಿಷನ್ ಮಾಡಿ ಡೇಟ್ ತಗೊಂಡೋಯ್ತು ಅಂದ್ರೆ ಪೆಟಿಷನರ್ ಅಡ್ವೊಕೇಟ್ ಬಂದು ಏನಾದ್ರು ಕಂಟೆಸ್ಟ್ ಮಾಡಿದ್ರೆ ನಮಗೆ ಅಲ್ಲಿ ಮೇಡಮ್ ಅದನ್ನ ಅಡ್ವಾನ್ಸ್ ಆಗಿ ತಗೊಂಡು ಏನ್ ರಿಪೀಟ್ ಮಾಡಕ್ ಹೇಳಿದಾರೆ ಮೇಡಮ್. ಲೆಟ್ ಇಟ್ ದೇರ್ ಇನ್ ಜಡ್ಜ್ಮೆಂಟ್. ನೀವು ನಾಳೆ ಬಂದಾಗ ಸಬ್ಮಿಷನ್ ಮಾಡಿ ನಿಮ್ ಸೀನಿಯರ್ ಕರ್ಕೊಂಡ್ಬಂದು. ಕೊಟ್ಟಿದ್ರಿ ನಾಳೆಗೆ ಸರ್, ಕೊಟ್ಟಿದ್ರಿ ನಾಳೆ.
ಏನ್ ಹೇಳಿ?
43 31st ಅಷ್ಟೇ ಸರ್ ಆಪ್ಷನ್ ಇರೋದು.
ಮ್ಯಾಮ್ ಲಿಸ್ಟ್ 2 ಮ್ಯಾಮ್.
ಮೇಡಮ್ ಲಿಸ್ಟ್ 1 ಸೀರಿಯಲ್ ನಂಬರ್ 79 ಏನಾಯ್ತು ಮೇಡಮ್?
ಲಿಸ್ಟ್ 2 ದೆಲ್ಲ ಹೇಳಿದ್ನಲ್ಲ ಇವ್ರೆ. ಅನ್ಲೆಸ್ ಎಕ್ಸ್ಟ್ರೀಮ್ ಅರ್ಜೆನ್ಸಿ ಪ್ಲೀಡೆಡ್ ಇನ್ ದ ಮಾರ್ನಿಂಗ್ ಐ ಕಾಂಟ್ ಅಸೈನ್ ದ ಡೇಟ್ಸ್. ಅದು ಹೋಗುತ್ತೆ. ಯಾವುದು? ಫ್ರೈಡೆ ಇತ್ತಾ? ಅಯ್ಯೋ ಇದೆಯಾ ಅದ್ರಲ್ಲಿ? ಅಲ್ಲಪ್ಪ ಪ್ರೀವಿಯಸ್ ಅಲ್ಲಿ ಐವೋ ಇದೆಯಾ? ಇದು ರವಿ ಲಿಸ್ಟ್ ನಂಬರ್ ಅಲ್ಲಿ ಐವೋ ಇದೆಯಾ ಅಂತ ಇದು ನೋಡ್ಕೊಳಪ್ಪ. ಎಂಟ್ರಿ ಮಾಡಿ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಿ ಹೋಗುತ್ತದೆ. ನೋಡ್ತೀರಿ ಅಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡಿ ಇದ್ರೆ ಮಾತ್ರನೇ. ಇಲ್ಲ ಅಂದ್ರೆ ನಾನು
ಎಲ್ಲ ಹೋಗುತ್ತೆ ನೋಡ್ಕೊತಾರೆ.
ಹೇಳಿ 29 ಅಲ್ಲಿ ಐವೋ ಇಲ್ವಾ? ಯಾವತ್ತು? 12/8 ತಗೊಳ್ಳಿ. ಹೇಳಿ.
ಸಮಾವೇಶ
ಸರ್ ಇದ್ರೊಳಗಡೆ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಎಷ್ಟೊಂದಿದೆ. ನಾನ್ ಫೈಲಿಂಗ್. ಒಂದ್ ನಿಮಿಷ ಕೇಳಿಸ್ಕೊಳ್ಳಿ, ಸುಮ್ನೆ ಕೇಳಿಸ್ಕೋಬೇಕು. ನಮ್ಗೆ ಈ ತರ ಇರೋದ್ಕೆಲ್ಲಾನು ಶಾರ್ಟ್ ಡೇಟ್ ಕೊಡಕ್ಕೆ ಡೈರೆಕ್ಷನ್ ಇಲ್ಲ. ನೀವು ಮೆಮೊ ಹ್ಯಾಂಡ್ ಸರ್ವಿಸ್ ಮೆಮೊ ತಗೊಂಡಿಲ್ಲ. ನಿಮ್ಮ ಹತ್ರ ಇದ್ರೆ ನಾವೇನು ಮಾಡಕ್ಕಲ್ಲ ಸರ್.
ಮೇಡಮ್ ಲಿಸ್ಟ್ 1 ಸೀರಿಯಲ್ ನಂಬರ್ 79 ಏನಾಯ್ತು ಮೇಡಮ್?
Ma'am, list 2 serial number 38 ma'am. ಮ್ಯಾಮ್ ಮ್ಯೂಟ್ ಆಗಿದೆ, ದಯವಿಟ್ಟು ನೋಡಿ ಅದನ್ನ. Court officer? Madam, ಮ್ಯಾಮ್ ಮ್ಯೂಟ್ ಆಗಿದೆ, ಏನೂ ಕೇಳಿಸ್ತಿಲ್ಲ. Ma'am, list 2, serial number 38, ma'am. Court officer, ma'am, ಮೇಡಮ್ ಮ್ಯಾಮ್ ನಿಮ್ಮ ವಾಯ್ಸ್ ಕೂಡ ಮ್ಯೂಟ್ ಆಗಿದೆ. ಒಂದೇ ಒಂದು ಮ್ಯಾಟರ್ಗೆ ಡೇಟ್ ಬೇಕಿತ್ತು, ಸ್ವಲ್ಪ ಎಮರ್ಜೆನ್ಸಿ ಇದೆ.